yeah, yeah. Junkie on the freeway, white claw in a breeze. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in chat. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the feed. We the California's rolling deep online. 4 corners, 1 crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you lost downstream, we gon' guide you like Californians. Yeah, we stay in the mix. 4 names, 1 flame, you can't remix this.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far.
She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big, you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing, got a Shamrock spark.
Yeah. Junkie, 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 junkie.
Susie, Shamrock, Shamrock.
Junkie, 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 junkie.
Susie, Shamrock, Shamrock.
We the California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, we stay in the mix. 4 names, 1 flame, can't remix this.
No, we do not get 2 times at it. Not now. Okay, so we are in our Josie Dikeman case. Welcome over. Hopefully everybody was able to hit that like button so we can let everybody know, look, we in this place. We still doing some things over here. Take it to trial. Shit, we got courtroom action, and as long as there's some courtroom fees, we in there. All right. So got our judge on the bench. I am going to take us into it, and let's do it. Do it. I don't know why Martina is still up. She must really be having some issues. She watched this. I want y'all to know she watched this without us. She watched this without us, and she needed friends. She needed friends. She needed us to be here to hold her hand because she almost fell in love with the Josie love bug. She didn't have none of y'all chat to help y'all. She didn't have a chat to help her. She surely didn't. She didn't have a chat to help her. No. So now I said now she gotta sit here with us so she can have some support so we can hold her hand through this. All right, guys, let's get into it. This judge, he tired of this case.
I don't know that the state can assert a factual basis for second-degree intentional at this point. As to count 3, I note that the lesser included is already kind of baked into the question of whether or not was this repeat child abuse and did it cause death. If that question is answered yes first and then no later, that's effectively a lesser included already. The other concern I would have is just examining this to make sure that with the various overlap of all of the possible lesser includeds that we're not getting into double jeopardy territory and or permitting convictions on 2 counts where the elements overlap.
Judge, to be clear, I'm not asking for second degree intentional. It'll go first degree intentional, first degree reckless, second degree reckless is how I've drafted it. And that avoids any elements overlapping issues. They're different elements.
Why don't you just share it with us and we'll take a look and we'll go from there.
Will do.
Okay, I believe the jury's here. Are there any other issues we need to talk about this morning, Mr. Torbenson?
No.
Mr. Zacher?
Yeah.
And just to be, I'm not trying to be rude, Attorney Bowles. I've just been addressing those two at the start. All right, and it's my understanding today we're going to be starting with the doctor.
Yeah, and I think it's appropriate if the court wants to briefly instruct the jury that because of the doctor's scheduling, we're going to break Ms. Dikeman's testimony, call him first, and Ms. Dikeman will resume her testimony after that.
Okay. I think that is appropriate. Dr. Rogue, right? Which doctor?
Dr. Christensen.
Dr. Christensen. I'm sorry. I don't know why I had that in the wrong person in mind. Okay. So we will we can bring the jury in. We'll start early. Okay, thank you, everyone. You may be seated. So before we begin today, first of all, thank you again for being here so much on time, and we're able to start a little bit earlier. The other thing is Dr. Christensen is going to be testifying this morning. The reason is there's a bit of a scheduling issue, so we'll be taking a break from Ms. Dikeman's examination and going into Dr. Christensen. The intention is we'll go back to Ms. Dikeman as soon as we're done with the doctor this morning. All right, with that, let's begin.
Your Honor, the defense calls Dr. Eric Christensen.
Yeah.
Do you solemnly swear the testimony given this matter shall be the truth, the whole truth, and nothing but the truth?
Oh, thank you. Go ahead. You might want to settle.
Thank you. Good morning, Doctor.
Good morning.
Would you please state and spell your name for the jury in court order?
My name is Eric Christensen. It's E-R-I-K. Last name C-H-R-I-S-T-E-N-S-E-N.
Doctor, what is your occupation?
I am a forensic pathologist.
And are you board certified in forensic pathology?
I am, yes.
What is your current position?
I am currently a full-time, well, actually part-time consultant in forensic pathology, where I am involved in the review of both criminal and civil cases involving deaths to assist the attorneys that hire me. Sometimes there are other people that hire me as well. I've been doing this as my only occupation for the last couple of years since retiring as the chief medical examiner for the state of Utah.
And Doctor, I'm approaching you with a document labeled Exhibit 311.
Yes.
What is that document? Is that a fairly current copy of your curriculum vitae?
It's a couple years old and it's missing the first 2 pages, but other than that, it's yes.
Thank you. Could you briefly describe your duties in your former role as a chief medical examiner?
I was responsible for the administration of a statewide medical examiner system. Our office was responsible for the investigation of all sudden, unexpected, or non-natural deaths within the state of Utah. That annually was somewhere in the neighborhood of 3,500 deaths a year. I supervised the work of 10 other forensic pathologists, as well as full-time investigative staff and autopsy assistant staff, and then various other people, clerical staff and epidemiologists and others.
And I know you don't have an exact number, but could you describe how many autopsies you've performed during your career?
Somewhere over 7,000.
And have you previously testified in court as an expert witness?
I have, yes.
And does your work include investigating deaths involving children?
It does.
And does your work also include reviewing toxicology results?
Yes, that's a routine part of forensic pathology work.
In preparing for your opinions on this case, Doctor, what materials did you review?
I reviewed medical records for Alex Xavier, both his birth records, outpatient pediatric records, hospitalization records related to his broken leg, and then events surrounding his death. I reviewed the information from the La Crosse County Sheriff's Office, a number of reports, and then the autopsy findings from Mayo Clinic and their associated documents.
And that would include toxicology findings?
Yes.
And are these the types of materials that forensic pathologists normally rely on in forming opinions?
Yes.
Now, Doctor, it is sometimes the case that a second autopsy may be conducted. Was that a realistic possibility in this case?
Not to my experience. Certainly by the time I was involved in the case, it was not an option.
And can you explain to the jury, you got into this a little bit, but what a forensic pathologist does?
Sure. So forensic pathology is a specialty of medicine, a subspecialty of pathology itself. Pathology is a specialty like surgery or internal medicine or pediatrics. And pathology is involved specifically with the understanding and elucidation of causes of disease. And forensic pathology is the application of general pathology skills to the investigation of sudden, unexpected, or violent deaths to evaluate them for trauma, with the ultimate aim of determining the cause of death for that individual, as well as what we call the manner of death, which is a description of the circumstances in which the death occurred. And that manner of death is a vital record function. It's something that we record on the death certificate by checking a box. It was either a natural death, it was an accident, it was a suicide, whatever it might have been.
And is your role to decide who is legally responsible for a death?
No.
And what does it mean when a death is classified as undetermined?
So undetermined is one of 5 choices for manner of death that we as pathologists have when we complete a death certificate. As I said, death can be determined to be natural, accident, suicide, homicide, and then the 5th option is undetermined. And undetermined is a manner that we use in cases where there is insufficient evidence to make a determination between 2 other manners. Most common example we see is probably an individual who has a history of substance use disorder, who is known to abuse, say, for example, opiates. But that person also has a history of depression and maybe even prior suicide attempts, and then that person is found dead of an overdose of opiates. In the absence of something like a note or something else to definitively help us know, was this just part of their usual drug use, or was this something they did on purpose at this time, we will certify many of those types of deaths as undetermined.
And the undetermined classification, that's used when medical evidence does not allow doctors to rule out multiple causes. Is that a fair?
Yes.
Statement? As you've indicated. Were you able to determine one definite cause of death in this case?
No.
What is your opinion regarding the cause of death?
I think this death is most appropriately certified as undetermined cause. That doesn't mean there's no idea what it is. Certainly there are many things that it is not. But ultimately, I think this comes down to a question of the impact of trauma and the impact of drugs. And there's not sufficient information to sort those 2 out.
And were you able to rule out drug intoxication as a cause of death?
I'm sorry, could you repeat that?
Were you able to rule out drug intoxication as a cause of death?
No.
And what do you believe was the most likely medical mechanism of death?
So mechanistically, the findings are most consistent with this child having died of respiratory failure. There are findings of pulmonary edema, which does take some time to develop. There are also some changes of cerebral edema and other indicators that the death occurred over a period of time, was not an instantaneous event. And that's most consistent with a death from respiratory failure.
And so you would agree with Dr. Quinton that his autopsy findings demonstrate a gradual dying process?
Yes.
And were the findings in this case consistent with injury caused by lack of oxygen to the brain?
That was the ultimate cause of the brain injury, yes.
And would you agree with Dr. Quinton that there's no evidence of lethal traumatic head injury?
I would agree with that, yes.
And did the autopsy show any evidence that Alex Xavier had been strangled?
No.
Did the autopsy demonstrate evidence that shows Alex Xavier had been asphyxiated or smothered?
No.
And let's talk about blood loss. Can severe blood loss deprive the brain of oxygen?
Oh, absolutely, yes.
And approximately how much blood loss is typically required to cause death?
That really varies depending on which source you read. The trauma literature provides some guidance, the pathology literature also some, but generally speaking, the number that's discussed is somewhere between 1/3 and 1/2 of all of your blood volume, which that varies by age. Children obviously have much less total blood than adults do. Obese people have more blood than skinny people. All of those, there are a number of factors that go into how much blood you have, but if you lose between 1/3 and 1/2 of your blood volume, that certainly can lead to your death.
And approximately how much internal bleeding was found in this case?
The measured amount of blood was about 100 milliliters. And in a child of this size, his total blood volume would be expected to be somewhere around, somewhere over 1.5 liters. So 1,500 milliliters or more.
And was the measured amount significantly less than would normally be associated with death from blood loss?
Yes.
And now, is it possible that some internal bleeding may not always be fully measurable?
That's absolutely the case. So when someone is injured, for example, I mean, we're all familiar with bruises. If you have a bruise, there's bleeding into that tissue that makes that bruise visible, but there's not any way to measure how much blood that is. And the same thing happens internally. In addition to blood that may fill up in cavities that we can actually collect and measure, you can also have blood within the soft tissues. In this case, Dr. Quint described hemorrhage within what's called the mesentery, which is the supportive structures for the intestines and around the head of the pancreas and a few other places within the back of the abdomen. You can't also, just like you can't really quantitate how much blood is in a bruise, there's not a way to quantitate how much is in that space, but you know that it's no more than what the volume of that tissue itself would be.
And so even considering the possibility that there was, in fact, some unmeasurable blood loss, was there evidence suggesting that blood loss was severe enough to cause death in this case?
I don't believe so, no.
Now, can a drug overdose cause death by reducing oxygen to the brain?
Yes, that's probably the most common mechanism.
And can you explain to the jury how that happens?
Sure. Any number of drugs can do this, but alprazolam, which is a question in this case, also is certainly known to do it. Anything that causes your breathing to slow or stop can lead to respiratory failure. So opiates particularly are known to do that, to even stop your breathing. But alprazolam and the other medications in its class are also known to slow your respirations. And if you normally breathe 12 to 15 times a minute, but the drug has slowed your breathing to 3 to 4 times a minute, that's just not going to be enough to get you all the oxygen you need. It's enough to keep you alive for even an extended period of time before you would actually die from that. But it's not going to be ultimately enough to keep your brain alive or to keep your heart happy. Those are both probably the two organs in your body that require the most oxygen.
And can overdose on alprazolam, also known as Xanax, can that slow or suppress breathing?
Yes.
Okay. And this would all be consistent with Dr. Quinton's description of this as a gradual process. Is that fair?
It would, yes.
And can alprazolam lead to hypoxic or anoxic brain injury?
Yes.
Can it also dull the senses?
Yes, and it can make you, typical symptoms, especially an overdose, would be, drowsiness, lethargy, confusion, slurred speech, all the way up to coma and death.
Now, how about with regard to pain?
It's not a pain medication per se. It's not like an opiate. It's blocking pain receptors in your body, but because it alters your thinking, it can dull your response to pain, yes.
Okay. So let's move on to the injury findings. Xavier had significant injuries, is that fair?
He had a number of significant injuries, yes.
And were those injuries consistent with blunt force trauma?
They are. Mm-hmm.
And does inflicted trauma necessarily mean the injuries were intentionally inflicted?
Can you ask that again?
But let me ask it a different way. But are you familiar with the ways that blunt liver injuries can occur?
Yes.
And can those types of injuries occur without somebody intentionally trying to kill a child?
Yes. So blunt injuries by their nature are nonspecific, with a few exceptions. I mean, if someone is stomped on with a boot with a particular pattern, that may leave a pattern that tells me it was that kind of boot. Or if someone is hit with an implement that leaves a specific type of pattern, then I might be able to say it's consistent with some rod-like implement or something sort of generally in that class of things. But for the most part, blunt injuries simply signify the interaction of a body with a blunt object. That can either be because the object is being moved against the person, or it can be because the person fell into whatever object it was. But the injury itself doesn't really tell you much about what caused it, short of a pattern that would reflect an implement, a specific implement.
And the injury patterns that you observed, would those be specific to one single cause?
No.
And would they be specific, strike that. Can forensic pathology determine the exact time an injury occurred?
No. Really, the best we can do is broad swaths of time. So an injury can have characteristics of being an acute injury, meaning it happened, anywhere from minutes ago or seconds ago, all the way up to, even a day would be, the sort of earliest, broadest category of what we can see based on those types of findings. As we start to see the body responding to that injury, meaning inflammatory cells come in and other things where the body's trying to clean up what has happened, that tells you that it didn't just happen, that it's been some number of hours or days since that happened. And then as the injuries then further heal, you start to see scar tissue and other things, and you know that those have been going on for days, but there's nothing you can look at pathologically that allows you to determine it was 3 hours ago or 5 hours ago or 12 hours ago. You know, the best you can say with findings that suggest it just happened, that it's probably somewhere in the last 24 hours.
And so you indicated the time frame for the possibility of injuries that were seen in the autopsy would be 24 hours.
More or less. And you know, all of the timing related to those things is subject to, you know, the addition of other information. So for example, it doesn't necessarily apply in this case, but if there was video evidence that showed an injury occurred 26 hours before this, it could still be consistent with that.
Now, could any of these injuries be consistent with rough play between children?
Yes.
And could you describe those injuries?
Sure. I mean, any injury, it really could involve any of the injuries this child has. Bruises, injuries related to the liver. You know, it would depend on the nature of the play, obviously. A routine kind of play is not going to do that, but if somebody gets shoved over, knocked over, stepped on, you know, other things certainly could lead to really any of these injuries. It's unlikely that that type of play would account for all of the injuries.
And if there was testimony establishing that the child's father had access to the child the prior evening between approximately 5:30 and 7:30, would the autopsy findings be consistent with injuries occurring during that time period?
Yes.
And could those injuries be consistent with being struck with an open hand?
They could be. Some could be, not all of them.
And others would require a different mechanism.
Yes.
Okay. And is it likely that multiple events contributed to the injuries?
Yes. I mean, just the distribution of the injuries on this child, you know, from head to extremities and torso, and all the different places are not consistent with all of this resulting from a single blow, if you will, or single impact. Just by their distribution, you know that it required multiple specific discrete impacts to cause those injuries.
And does that require a prolonged time period?
No. I mean, it could be. You can't say that it's not. I mean, within the time frame of 24 hours, they all would look more or less the same pathologically. You can't really distinguish them that way, but just from the physical act of causing the injuries, certainly it could be quick or it could be protracted. There's not a way to know from looking at them.
And do these injuries as a whole prove that homicidal violence occurred?
No. I mean, it's back to that whole question of specificity. You know, blunt injuries are blunt injuries. If they are accidental in nature, which you can't tell by looking, or inflicted trauma, you can't distinguish that just from looking at them.
And did you find injuries that would typically Did you find injuries that would typically be associated with an intentional homicide?
Objection, that calls for a comment on the mental state of the person. The jury.
Well, I think he has experience with determining the severity of injuries and whether they're consistent with an intent to actually cause death. That certainly is within his
expertise. His job, you just testified to that.
So this is, I believe the question's about, there's the different use of intentional act versus non-intentional act in medical. Is that correct? Is that what you're asking about? Not the elements, but the medical?
I guess the point I'm getting at is did the injuries demonstrate that the person who caused them intended the child to die?
Yeah, I'll allow him to ask that question.
So blunt injuries, again, are non-specific. Generally in cases that I see where the cause of death is distinctly or definitely results from violent actions, violent blunt force applied by another individual. I would expect to see more trauma in the head, more trauma in other locations than what I see present in this case.
And doctor, do the autopsy findings instead suggest another possible cause of death that was more likely?
Yes.
Specifically, would that be consistent with anoxic brain injury caused by alprazolam intoxication?
Yes.
And doctor, you talked a little bit about this, but I don't know if we got into all of the details. What is alprazolam?
Alprazolam is a benzodiazepine medication. It's used to treat anxiety by itself, used to treat anxiety associated with depression, and it's part of a class of other similar medications. It's one of the more common ones that's prescribed for that indication, and it has sedating effects.
Okay. And can you elaborate on those effects that alprazolam can have in an overdose situation?
Sure. Like I mentioned before, lethargy, inability in coordination, stumbling, slurred speech is described. And then, on that spectrum, as a person becomes more and more affected by it, can lead to coma and even death.
And you've indicated it can suppress breathing and that would reduce oxygen flow to the brain.
It can, yes.
And can that lead to death?
And that lead to anoxic brain injury.
But let me ask you, did the toxicology testing show alprazolam in Alex Xavier's system?
It showed, yes, alprazolam was present at a high level in his blood.
And what was the level of alprazolam in Alex Xavier's system?
The measured number was 250 nanograms per milliliter.
And you said the measured level, that was measured from a sample of blood taken during the autopsy?
It was a sample taken at autopsy of what was described as what's called cavity blood. So it was not blood that they were able to get from a vessel itself. And when you take blood from a cavity, it's obviously still blood, but you don't know necessarily what else it might be mixed with. Was there, fluid present in the pleural cavity before the blood leaked into there that you collected? And so it's not reliable as a means of determining specifically whether the level that you get. You just don't. There's not reference ranges for cavity blood. You don't really know what that number means in cavity blood, except that the substance is present in the system. But you don't know how that level would compare to a sample taken from a blood vessel.
And so, in other words, we can't take that result and conclude automatically that that was representative of the level that was found in Alex Xavier's circulating blood.
That's correct.
Is it possible, however, that the level that you found was the level that was in Alex Xavier's circulating blood?
That's certainly possible.
And you indicated 250 nanograms per milliliter. What is the level that is considered potentially fatal in adults?
So in adults, the typical range for toxicity starts somewhere around 100. Deaths have been reported at levels as low as 140 in adults. In children, we don't really have good reference ranges because it's not a drug that children take very frequently. I mean, certainly I'm sure there are children that are prescribed it, but it's not something that there's a lot of data about, especially not in a postmortem setting. And so we don't know necessarily what it means in children, but it's the level that is measured in him would be certainly very high for an adult and would be sufficient to explain that adult's death.
And doctor, can children be even more vulnerable to those effects?
It depends on the medication, but yes, is the short answer. And
is alprazolam overdose a reasonable explanation for Alex Xavier's injuries?
For his anoxic brain injury, yes. He certainly could be caused by that.
And can an overdose be accidental?
Yes.
Now, we talked about some of the symptoms of alprazolam. And you've indicated it can cause lethargy. Is that fair?
Yes.
Could it cause a person to be unusually difficult to wake up?
Yes.
And can it reduce responsiveness to pain or stimulation?
Yes.
And if there was testimony that law enforcement officers were present in the home between 7 and 7:30 and observed Alex Xavier had very difficult time arousing him, would that be consistent potentially with alprazolam intoxication?
It would, yes.
And in failing to wake in response to a flashlight, that would be consistent?
It certainly could be caused by alprazolam, yes.
And would slurred speech before falling into a deep sleep also be consistent?
Yes.
And did you find any evidence? Well, let me ask. Would a history of a child waking up at night and getting into things also be important contextual information?
Yes.
Okay. And did you find any evidence that alprazolam had been forcibly administered?
No.
And what might you expect to see if that were the case?
So, in a forced administration, the assumption is that the person doesn't want to take it and they're resisting. And if you've had a situation like that, you might expect to see injuries around the person's mouth and other things of that nature, but there's no indication of that.
And let's talk a little bit about something different about CPR. You're familiar with CPR, is that
yes.
Right? And if there was testimony that Alex Xavier had either white foam or black liquid emitting from his mouth immediately after first responders began to move him to the floor and perform CPR, what would you make of that?
I mean, it would not really be unexpected. The most significant finding of those two that you mentioned is certainly the presence of a white foam is consistent with respiratory failure, but the presence of black fluid coming from the mouth doesn't really mean anything to me.
As an expert who looks at these things, would that prove that someone had not previously attempted CPR on Alex Xavier?
No, it would not.
And the black fluid, would that necessarily be blood?
No, I've had many cases over the years where a person had blackish material either on their face or coming from their mouth. The investigators at the scene had said, "Oh, we think this is blood," and when looked at and tested, was not blood. After you eat something and it sits in your stomach for a while, a lot of things can give that appearance.
One moment. And Doctor, there were bruises found on Alex Xavier in the autopsy. Is that fair?
The other were, yes.
And bruises, do those immediately appear after an injury is suffered?
Not necessarily, no.
And could they be not visible after an injury and then appear later?
Yes.
And there was discussion also about a potential lethargy seen in Alex Xavier, difficulty in waking him when the law enforcement came through the house. Could that also be consistent with a concussion or mild TBI?
Possibly, yes.
And that can cause loss of consciousness?
It can. I mean, that's part of, how traumatic brain injuries can be defined as the length of unconsciousness associated with a concussive injury in particular. So.
Thank you, Doctor. I have nothing further.
Thank you.
Cross?
Morning, Doctor.
Good morning.
Doctor, you are retired from your job as a pathologist in Utah, correct?
I'm retired from my work for the state, yes.
Correct. And in your work for the state, whenever you performed an autopsy, you would have to author a report relative to that autopsy. Isn't that right?
That's correct.
It's mandated as part of your work as a forensic pathologist that whenever you're performing an autopsy and conducting work, that you document all of your findings and conclusions.
Objection, this is irrelevant.
It's very relevant.
Overruled.
Correct?
So it varies depending on where you are, but most states require that if you conduct an autopsy, that you reduce the findings from your autopsy to a written report. Yes, and that
didn't author a report in this case, did you?
No, but I didn't conduct the autopsy.
As a defense expert, you have the ability to author a report, correct?
I do many times.
And oftentimes you are asked to write a formal report with your findings and conclusions. Isn't that right?
Required by the statute, and this is some of it.
Well, you didn't author a formal report. Go ahead.
You didn't author a report with your findings and conclusions, correct?
I did not in this
Did you
case.
provide any written statements regarding your findings and conclusions to the defense?
No.
You did not?
No.
Okay, so you provided no information to the defense in writing that the state could have and examine. Is that fair?
Yes.
Okay, all the information that you provided to them, you provided verbally?
Correct.
Okay. How much did it cost for your consultation on this case?
I don't know. I mean, I bill for my time and experience basically at a rate of $500 an hour.
Doctor, you know when you walk into this courtroom that I'm going to ask you questions relative to how much you pay, correct?
Yes.
Okay. And you came into court today knowing that I was going to ask these questions, and you are saying that you didn't figure out the amount, knowing that I was going to ask you these questions today. Is that right?
Well, I didn't know that you would specifically ask that total amount question, but I can give you a ballpark. I mean,
every time you testify as a defense expert, you're asked these questions.
No, not every time. No.
Okay. The majority of the time you testify as a defense expert, you are asked these questions.
Sometimes I am, sometimes I'm not.
Okay. And you said $500 an hour. How many hours did you put into this case?
I started working on this case in 2023. I would guess at this point, I have put in somewhere around 20 hours.
20 hours?
Yes.
At $500 an hour?
Yes.
On top of that, $500 an hour for 20 hours, you get paid separate and distinctly for your testimony today. Isn't that correct?
I don't get paid for my testimony. I get paid to appear and testify. What I say is not what I'm being paid for.
Thank you for clarifying that. You get paid to appear and testify, and that's at a different rate than that $500 an hour for 20 hours. Isn't that right?
No, it's the same rate.
The same rate. So the longer you spend on the stand, the more money you make today.
No, for court appearances, I mean, I still bill at the same hourly rate, but I bill it in half-day increments. So if I'm here for half a day, then it's $2,000. If I'm here for a full day, it's $4,000.
So half day is $2,000, full day is $4,000. That's different than what you originally said. You said you originally would bill it out at $500 an hour. That's not what you just answered, though, is it?
Not exactly, no.
Not exactly, no. It's important in your profession to be accurate, correct?
I would say so, yes.
You're used to answering questions from attorneys based on your profession, correct?
Correct.
And I just asked you a pretty clear question and you got the answer wrong. Isn't that right?
If you can interpret it that way, yes.
How do you interpret it?
My rate is, I answered the question related to how I bill. And
you don't bill $500 an hour for testimony. You bill half day or full day. I asked you how you bill for testimony, and you originally said $500 an hour.
Asked and answered. He's better than a witness at this point. Objection. Asked and answered. He's
sustained. Move on.
So you gave all the answers to the defense verbally, not in any written fashion. We covered that, correct?
Yes.
asked and answered.
I was laying foundation for the next question.
Go ahead.
Now, this child suffered multiple blunt force impacts all over his body.
Yes.
Multiple to the head.
Yes.
Multiple to the side of the eye on different planes. Isn't that right?
Yes.
Multiple that were revealed once his hair was shaved, correct?
Yes.
Multiple different portions of the head, correct?
Yes.
Each one of the bruises that are documented by Dr. Quinton in his autopsy is a separate and distinct blow to the head to Alex Xavier Pedron. Isn't that right?
Yes.
An assaultive blow, correct?
I don't know. Can't tell from looking at them.
You can look at the fact that there's so many blows on different planes and different sides of his head that you can say it's not an accident, right?
Not necessarily. I mean, certainly the cumulative total of them suggests that they are inflicted. I will agree with that, yes.
Okay.
But any specific injury, you can't say that.
When you're practicing medicine, you're applying the differential diagnostic process, isn't that right?
Yes.
And explain to the jury, no, I'll tell you, the differential diagnostic process is looking at the child as a whole or the patient as a whole and their entire conditions correctly?
Yes.
And making a diagnosis as to what makes sense based on the entire clinical picture you're seeing, right?
Yes.
So we don't just look at one bruise on the head or one bruise on the other side of the head or the injuries to the organs. It's important to look at all of the injuries, the entire constellation of injuries on this child's body as a whole.
Yes, that is true.
And the entire physical injuries on this child's body, the constellation of injuries as a whole, demonstrate that this child was violently assaulted. Isn't that right?
Not word I would use. I mean, there's no question that his injuries in total are consistent with inflicted abuse, that he was abused.
Inflicted child abuse. Correct?
He's
He's
a child, yes.
All right. This is inflicted abuse of a child, right?
Yes. Mm-hmm.
And we can also reasonably conclude that the medication, the Xanax that's in his system, he ingested, however you want to say he took it, that happened after the abuse, right?
Actually, I don't think we can say that. We don't know either, within a 24-hour window, we can say when the injuries happened, but we have no idea when the medication was administered, either to him or he did it himself. We don't know.
You would agree that this is a very high level of Xanax in his system?
Well, it's a high level in his cavity blood that we don't know what it means with respect to his system.
You just testified under direct examination that this level in an adult could be toxic to an adult and maybe cause the death of an adult.
Yes, if it's a blood level. Yes.
And you also testified under direct examination that it's wholly possible that the result from the cavity blood may be the actual result that was in his system. You said that when they asked you the question.
Yes, they may.
It may be, right?
Yes.
Okay. Now, if this child ingests that level of this drug, it's going to make him symptomatic really quick. Isn't that right?
I don't know.
You don't know.
I would expect it. So you can't infer from a given level in someone's blood how much of a dose they took. You know that you can say given the given level would require more than say one pill. But beyond that, you can't say, and because we don't really have good data about what these levels mean in children, there's not a good way to say what this specific level means with how much he ingested. With respect to your specific question of how soon he would be symptomatic, that would be a function certainly of how much he ingested, but I don't know how much he ingested, but it certainly could be quick.
Well, when people take medication, they don't take it so it can take effect 14 hours later, correct?
Oh, no, I would not expect it to take that kind of time.
Take it so it can take effect rather quickly.
Yes.
And Xanax or olanzapam is a pill that someone takes so that it can take effect within an hour or so. Isn't that right? In general?
Generally speaking, yes.
So you'd expect the effects of that pill to take place within at least an hour. Isn't that right?
I would expect so.
Now, you testified that, and going back to the injuries and my question related to the injuries of this child, it doesn't make sense that someone beats a child after the child's unconscious from a pill, correct? That just defies logic.
That's correct.
That makes no sense whatsoever.
From a practical standpoint, I mean, that's a common sense opinion.
Yeah, so when we look at the entire clinical picture of this child as a whole, we can safely say that this child was physically abused and then was given Xanax afterwards or took Xanax on his own afterwards, which is your conclusion. Is that correct?
That certainly would be an explanation, yes.
Now, it's important when we're looking at how this child got Xanax in the child's system that we consider the fact that he was abused, right?
I mean, it's part of the whole context, yes.
We can't ignore that, right? Because that's not the practice of medicine.
No.
We have to look at those injuries and the abuse, right?
Yes.
We have to look at the severity of those injuries and the abuse, right?
Yes.
Those injuries are going to be symptomatic, aren't they?
I would expect there would be some symptoms, yes.
For example, a rib fracture. He has a fractured 10th posterior rib. That's a painful thing.
I would expect so.
Even when he breathes, right?
Yes.
He's going to feel that pain.
I would expect so, yes.
Okay. You were asked questions relative to when he was observed by law enforcement and he was described as lethargic and things of that nature when law enforcement was on scene. Did you actually watch that body cam?
I did.
You did watch that body cam?
Yes.
Okay. You had the police reports relative to the statements of witnesses afterwards, correct?
Yes.
And you were aware that he was described as being awake and alert after that, correct?
Correct.
That would be inconsistent with him having olanzapam in his system at that point. Isn't that right?
Can you repeat that?
Yes. Him being described, Xavier being described as awake and alert for hours and hours after law enforcement came to the residence would be inconsistent with him having olanzapam or Xanax in his system at that point in time when law enforcement came.
Mischaracterizing the evidence.
I believe part of it is, there is a phrase that at some point he was awake and alert. Go ahead.
So sorry, can you repeat it again?
Let's just go over the time frame.
Sure.
You're aware that this defendant described that Xavier was awake watching TV with her until 3 o'clock in the morning.
Yes.
Okay. You're aware that this defendant described that she tried to put Xavier to sleep around midnight and he wouldn't go to sleep, so she turned the TV back on.
Yes.
You're aware of those facts?
Yes.
You're aware that this defendant's mother stopped by the house after 9 p.m. to pick up 2 older children and described Xavier as laughing and playing with the other children.
Objection, hearsay.
It goes to his opinion.
No, overruled. Go ahead.
You're aware of that information, correct?
Yes.
You're aware that there's a phone call between this defendant and Laura Lee, her friend, at 10:30 at night where they both describe Xavier saying the same thing, that he wanted to get up in the middle of the night and get into some trouble, right?
Yes.
You're aware of all that information.
Yes.
And all that information flies in the face of this child having Olazepam or Xanax in his system at 7 o'clock when law enforcement's on scene. Isn't that right? They open the door to this. They absolutely talk about it.
Yep, overruled.
So it doesn't, you know, I guess what I would say is it doesn't exclude the possibility that he took Xanax, but it certainly would require for him to be dead of it to have taken it again.
What? I'm sorry, I missed that.
It would require him, if his initial lethargy and other things were caused by Xanax, and then he seemed to be up and moving around, and then is ultimately dead from Xanax, would require him to have taken more Xanax.
Taken more?
Yes.
Yes. And his sleepiness from 5 to 7 p.m. could be from the melatonin he took. Isn't that right?
Potentially.
You're aware that he had melatonin in his system, correct?
Yes.
One of the other toxicology findings in this case was caffeine. There was caffeine, presumptive positive for caffeine in his system, correct?
Yes.
You're aware that Alex Xavier, one of the things or claims made was that Alex Xavier would get up in the middle of the night, right?
Yes.
And he would look for things to eat or drink, correct?
Yeah, correct.
And having caffeine in his system would be consistent with ingesting, for example, a Red Bull in the middle of the night.
It certainly would be. Mm-hmm.
And Red Bull has caffeine in it, quite a large amount.
It does. It does.
I want to talk to you a little bit about the liver laceration. That would also be a very painful injury, isn't that right?
The liver itself, you don't have a lot of good discrete pain receptors within your internal organs. So from a pain standpoint, you wouldn't necessarily be able to say, oh, my liver has been injured, but certainly the bleeding that would be associated with that, blood within the abdominal cavity is generally, in most people, described as a painful thing.
Described as painful, correct?
Correct.
And he has not only a lacerated liver, but he has damage to other organs as well, isn't that correct?
He has some hemorrhage around his pancreas, he has hemorrhage around his initial part of his small intestine, and in the wall of his small intestine, yes.
There's been studies to demonstrate the type of forces necessary to cause liver lacerations or internal organ lacerations to children. Isn't that right?
I believe there are. If I've seen them, it's been a while. But
it's something that would be important for you to know when you testify here as an expert regarding a liver laceration in the child, correct?
Certainly, it requires a fair amount of force to lacerate a liver.
A fair amount of force, right? We don't see children just coming into hospitals on a daily or weekly basis with lacerated livers from minor trauma.
No.
It requires something rather significant.
Yes.
One of the ways that children suffer liver lacerations is when they ride their bikes and they come to an abrupt stop and their handlebars go directly into their stomach.
Correct.
That's the type of force it causes, where the handlebars go into the stomach and they tumble over their bikes, right?
Yes.
A real blow of something that's pushing the organs against the back spine, correct?
Correct.
That's the type of force we're talking about here.
That's an example of it, yes.
Yes, of what we need to cause these injuries.
Yes, and I mean, those types of injuries, bicycle handlebar injuries, certainly can be much more severe than what is present in this case, but the mechanism is accurate.
When we talk about the possibility of Alex Xavier getting up and taking this medication after he suffered this beating, we have to take into account first that he's got a broken leg, correct?
Yes, I mean, it's healing, he's in a cast, but yes.
He's got limited mobility.
I don't know specifically what his mobility was.
You're aware, are you aware from the records that you reviewed, the law enforcement records, that he wasn't supposed to walk at all on that leg?
I seem to recall that now that you said that, but I don't remember specifically.
Did you review the scene photographs in this case?
I did.
Are you aware that he was supposed to use a walker if he's walking on his own?
I don't recall specifically whether he was supposed to or not.
Are you aware of where the walker was located by law enforcement when they conducted the scene
I do
investigation?
not recall, no.
Do you know that it was folded away and he wasn't even using it?
No.
There's no fact, not in evidence.
I asked him if he was aware of it.
That's speculative. That's
All right. Overruled. Go ahead.
Not aware.
And just so it's clear, being aware or not aware does not mean the facts are in evidence. It just, he's not aware of it.
Alex Xavier had bruising on his hands, correct?
Some, yes. Mm-hmm.
That's an additional area where he was assaulted.
Well,
speculation.
Yeah, I don't know.
He says, I don't know. Overruled.
An additional area where there's blunt force injuries noted on his body.
Could you repeat that?
It's an additional area where he has blunt force injuries on his body.
He does have blunt injuries, yes.
On his hands.
Yes.
The pill bottle that was located on scene, that had child safety locks on it, isn't that right?
That's my understanding, yes.
Okay. What do you recall about all the pill bottles that were located in the bag where that pill bottle is purported to have come from?
Sorry, purported to come from, I don't know. I mean, it was my belief, or my understanding is that the bottle found next to him was for prednisone, which was not tested for and not identified, whether he took any of that or not. But beyond that, I don't know.
You don't believe he was tested for prednisone on toxicology?
No.
Really?
Really?
Are you sure about that?
But nearly 100%, yes.
Yeah, they didn't look for prednisone in Alex Xavier's autopsy.
That's not a routine part of any forensic pathology tox testing that I'm aware of.
In this case, they had concern for prednisone, and you're saying that when they tested Alex Xavier's toxicology, they did not look first for prednisone. As you sit there under oath, that's what you're telling this jury?
That's my recollection,
That's
yes.
your recollection? Yeah, I'm asking if we can just take a brief break. I want to get the autopsy toxicology report.
If you find it, go ahead. What's that?
It's important to get facts right when you're testifying under oath, right?
Yes.
Okay. And as you sit there right now, you're telling us that in a case where it is originally believed that this may be a prednisone overdose, nobody tested for prednisone. That's what you're telling us.
That's my belief, yes.
That's your belief. And it'd be important for you, before you take the stand, to review all the documentation and make sure that you have a mastery of the facts, correct?
Yes.
And if you got that wrong, that would be a big mistake on your part.
I don't know about big, but yeah, it would depend on the relevance of the finding.
Well, that was one of the original concerns for the cause of death in this case, isn't it? Prednisone.
Well, it was found next to him, and so yes, they would be concerned that he took it. I'm not aware of any cases of death by overdose from prednisone.
It's just, if you're looking for the autopsy report, it's Exhibit 27.
Blows to the head can cause swelling of the brain, correct?
Could you say blows to the head can cause swelling of the brain? By themselves, generally no, but
If there's multiple
if there's what?
blows to the head?
It would depend on what they do, but generally speaking, no.
Doctor, you may be right on the prednisone. I thought there was a screen for it. I'll come back to that issue. When we're talking about the investigation of the scene in this particular case, the rest of the pill bottles that were contained inside that bag all had the caps on them. Is that correct?
Yes,
They all had the exact prescribed medication that matched the label inside. Isn't that correct?
that's my understanding, yes.
And that's a factor for you to take into account too when you're looking at how the medication got inside of Alex Xavier. Isn't that right?
Yes,
They all had the child box engaged. Isn't that right?
it's my understanding, yes.
And it's important to take into consideration the developmental capabilities of Alex Xavier. Isn't that right?
Yes,
And child box would be a safety mechanism on that container that would keep a child of Alex Xavier's age from getting into that.
that would be why it's, oh, sorry.
What was your question again?
A child safety lock that is engaged on a pill bottle would be something that would keep a 6-year-old child from getting into that medication.
Yeah, overruled, go ahead.
So that would certainly be the intent of its design. Whether there's no 6-year-old that can get into it, I can't answer.
It would require a child to both push down and turn, correct?
The usual mechanism, yes.
You're aware of where the bag was found?
I don't recall.
You don't recall where the bag was found?
No.
It's found next to his body. Does that help you recall?
No.
It'd be fair to say that based on the description of how Alex Xavier was acting that evening, that he took in that lorazepam or Xanax sometime after 2 or 3 o'clock in the morning. Isn't that right?
Speculation.
Given his earlier testimony, I'll allow that question to be asked. Go ahead.
That would be expected, yes.
That'd be expected. It happened after that time frame.
Yes.
And you're aware that this defendant and only this defendant was home with Alex Xavier for the last 14 hours of his life.
Yes.
Question. That's asked and answered and mischaracterizes the evidence.
It wasn't asked and answered, and you just said yes.
Doesn't matter what his answer is, it doesn't mischaracterize the evidence. Go ahead.
Yes, she was the only one home for that time frame, correct?
Yes.
Only adult home.
Correct. Thank you, Judge.
Okay. Can I just correct something? You said 14 hours, but I believe you had said there was evidence of somebody being there at 9:30? Somebody picking up?
Sure.
Yeah,
I'll
so it's
clarify
not
that.
14 hours, 12 hours.
Um,
I mean, I'm just trying to, that there was an objection on the basis of the factual mischaracterization. I just don't want it to be mischaracterized. What was the actual? What?
We get cyber.
Yep.
You're aware that the first responders described Xavier's body still a little bit warm to the touch. Is that fair?
Yes.
Okay. That demonstrates that he would have died relatively recently to when they responded, within an hour or so.
I don't think it tells us that at all. I mean, the cooling of the body is a very wishy-washy, it's not a very precise way of determining how long someone's been dead.
There's a lot of factors that go into it, like the temperature of the room, correct?
Correct.
The size of the body,
Yes.
and the age of the individual, things of that nature, right?
There are a number of things that influence that, yes.
It's been studied, but it's not precise.
And no, definitely not precise.
When I gave the 14-hour range, I'm going to clarify a little bit more. We know that an adult stopped by to pick up 2 adult children. Is that correct?
Yes.
And that adult was the defendant's mother. Is that right?
Yes.
And when that adult, the defendant's mother, stopped by to pick up the 2 older children, the defendant was there with her mother that time frame, correct? According to the reports?
Yes.
They were engaging with one another.
That's my understanding, yes.
And she picked up those 2 children and left, correct?
Correct.
There's no evidence whatsoever that that other adult was in any way, shape, or form left alone with Xavier.
That's my understanding, yes.
Okay. And after that adult, the defendant's mother picks up the 2 older children, it's this defendant and this defendant alone is the only adult in the home.
Correct.
And that's after roughly 9:30 p.m., correct?
Yes.
And that goes until 9:25 a.m. when first responders are on scene. Is that right?
Correct.
Thank you, Doctor. That's all I have.
All right, redirect.
Doctor, do we know when exactly Xavier died?
No.
And Xavier, when he was discovered in the morning, he was in a state of rigor mortis. Is that correct?
Yes.
And what does that tell you?
I mean, it's another thing like cooling of the body. There are certain changes that happen in the body post-mortem. The body will cool off, the body becomes stiff, and blood, settles into the lowest portions of the body. All of those things happen in a sort of gradual, progressive way over time. When a person first dies, there's no evidence of stiffening. There's no visible evidence of lividity or that pooling of the blood. And they're going to feel essentially as warm as they did. Most of the studies on postmortem cooling say that there's at least a plateau period initially where the body will remain at its normal temperature for a period of time, an hour or more. But the stiffening of the body happens in a progressive way, usually is present within an hour or 2. Becomes more developed and stays then fully developed after a period of about 12 hours until the body starts to decompose. But the presence of that, we just don't know how long. I mean, it doesn't tell us enough, nothing really informative as far as how long they've been dead, other than, if the presence of rigor mortis suggests they didn't just die. So it's probably been an hour or more. But again, other findings, if there was video that said, he was doing this, 45 minutes before, it certainly could be consistent with that, but could be really anywhere beyond that time frame.
Now, the government's lawyer made a big deal about how Dr. Quinton ordered testing for prednisone. You remember that?
Yes.
And in fact, was that the case? Did they test for prednisone?
I don't believe so, no.
And is that something they could have tested for?
I'm not aware of a lab that offers that testing specifically. I'm sure there are research labs somewhere that can look at that question, but it's not in the setting of postmortem toxicology. Most anything that can be used to lead to, cause, or contribute to someone's death has been looked at in terms of the ability to test for it. Like I said before, I haven't seen a case of someone dying of a prednisone overdose, and I'm not aware of a lab that specifically includes that as part of any of their routine screens.
That could have been a possibility. Is that your testimony?
It's possible that testing could be done, but I don't know where that would be.
Now, there was some discussion of child locks. Are child locks 100% child proof?
I'm not a product expert, don't know. I would guess not, but given the resourcefulness of children, but I don't know.
And you testified that we don't know when the alprazolam was ingested. Is that fair?
No, and we also don't know if it came from a bottle.
And we don't know if it was ingested multiple times, perhaps?
We don't. I mean, what we have is a single level in a blood sample that's not terribly helpful in terms of interpretation. We know that he has Xanax in his system, But that one level, even if it was a good, femoral blood sample, we don't know whether that represents one ingestion, multiple ingestions over time. There's not a way to know that from that single level. That's just a snapshot of what's going on in his blood at the time of his death.
And does the evidence support that there could have been initially a lower dose administered and then a later higher dose that was ingested?
That's possible.
And is it also possible that the child suffered a concussion and the effects of that, and then later ingested alprazolam?
Also possible, yes.
Now, there was some discussion about the types of forces and mechanisms that can lead to the liver laceration. Do you recall those questions?
Yes.
Would it be something that could be caused by a strong and angry man who can inflict those injuries?
Certainly that's possible.
And there was also some questions about whether you're getting paid to perform your job. Is it normal for people to get paid for their time?
Yes.
And doctor, are all of your opinions held to a reasonable degree of medical certainty?
Yes. And to me, what that means is, that within my understanding of the science and the medicine behind the things I've testified to, that these are reasonable conclusions.
And so your opinion remains that this was an undetermined death?
Yes.
Doctor, just to be clear, a forensic pathologist, you are not to opine on who did something, right?
Yeah, I don't know who did it.
That's for the jury to determine, correct?
Correct.
So when you're asked to speculate on whether an adult man could do it, an adult woman could do it too, right?
Possible.
Right?
Yes.
That's not for you to decide, is it?
I mean, I don't have any way to know that. I can tell you that the injuries are consistent with an adult having caused them, but which adult, I don't know.
That's all I have. Thanks.
All right. Thank you, doctor. I'm not sure. Oh, yeah, you do have a.
Okay.
Move admission of exhibit 311.
Thank you. Any objection?
No, that's a CD.
That's a CD, yeah.
Yeah, no objection.
Okay, we
We'll
received.
get a complete.
Let's take a little break, and then we'll go into the next testimony. So it's about 5:02. All right, we'll see you then. About 5:02.
5:02. Okay, thank you.
Was actually a transaction, and my understanding is that that's what Mr. Colkind would say as well. I don't know that that's opening the door, and I would ask the court to prohibit cross-examination on that topic.
Counsel.
I think the report is very different. I think she actually admits to buying pills from him, oxycodone pills that she originally had an addiction to in 2011 to 2013, pills that she said when she was on the stand, she graduated from drug treatment court and has never used again since then, or not used without a valid prescription. And her very specific statement, I believe in the report, says that she admits to buying oxycodone pills from Ted Colkind.
Obviously, I'm letting you take a look at the report.
Judge, this is all that we have, and I'll put in the record here if you want. But it's a follow-up report from Deputy Bedhauser, who I'm not sure if she's still with the Sheriff's Department or not, from September 9th of 2019. It's a single paragraph where she says she made contact with Josie that indicated that Ted had previously offered her some medications. She showed Deputy Bedhauser a conversation between she and Ted from July 15th in which she inquired about having some of the medications. Ted replied, sure, no problem. When she asked him how much money she had to give him for them, he said $1 million, and then it included a time to exchange the pills, but there's no indication that that exchange actually took place.
That's in the report that it says,
Yes.
it says no indication.
No, it does not. It does not. Oh, well. Yeah, she indicated recontact with Ted Colkind, returned to Ted's residence, gave his oxycodone and OxyContin medication back to him, along with Jeep keys, asked if he had previously provided Josie with some of his prescription medications. Mr. Colkine told her that he did not remember and did not remember their text conversation. Said that when she mentioned how he joked about the price of the medication being $1 million, Mr. Colkine was just kidding about that.
All right. I don't think if that's the response, he's not saying that he actually exchanged it. And obviously $1 million was a joke. I think the state would think that is true.
I think his reference to it costing $1 million for the drug transaction is a joke. I agree with that. I don't think he's saying that the rest of that didn't happen or that the whole thing was a joke. And when she's being interviewed, she very clearly is telling law enforcement she's seeking this medication from him. She's asking, can I have your OxyContin? That's drug seeking behavior of a prescription medication that is not her prescription, which goes directly against what she testified to on the stand.
She testified that she did not take. She has not taken.
She has not received medication from the Colkine. She's admitted that she's received medication from her mother. We've acknowledged that, but specific to Mr. Colkine, no.
All right. I don't believe it's opened the door. We'll go from there. Okay.
Judge, if I get further clarification from that sergeant that says she actually admitted to the transaction.
And it's not in any report?
Yes.
From a 2019 situation? No. We're moving on. Okay, let's bring the jury in.
Judge, just for the record, I want to note that there's no evidence that there was an actual drug transaction with the text messages they introduced with regards to Mr. Pedrin. And this is the exact.
The jury coming in.
Jury coming in. You're late.
Like, could you pull my legal pad from yesterday? I was using it. Thank you.
All right, everybody be seated. We're going to continue with the testimony of Ms. Dikeman. Ms. Dikeman, why don't we have you come up and we'll have you re-sworn and have you take the stand.
You solemnly swear the testimony given this matter shall be the truth, the whole truth, and nothing but the truth.
Go ahead.
Josie, I want to start back in the days leading up to Alex's death. Were there ever times when you reached out to Derek's mom for help controlling him?
Yes.
Why did you do that?
Because I was scared to call the police, so I thought I could call his mom.
All right, I'm approaching you with what's been marked as Exhibit 312. So this does this appear to be a Facebook exchange between you and Mrs. McCormick?
Yes.
And for the record, the top entry is dated UTC February 1st of 2023, 9:17 and 4 seconds UTC, which would be about 3:17 a.m. on the 1st. Is that correct?
Yes.
Josie, did you ask Ms. McCormick if she was awake?
I did.
And did you tell her why you needed her help?
Yes.
What did you tell her? Right.
I said, sorry, he's been drinking a lot and I'm not sure what to do.
Offer 312.
Any objection?
No.
Received.
Josie, was that the same day that you sent Derek the text where you said that you were too scared to even go to sleep?
Yes.
Was Derek's behavior out of control at that point?
Yes.
Was his mom ever able to calm him down or have him behave normally in the house?
No.
Did Derek's behavior continue to be violent and erratic from the date of that Facebook exchange on February 1st up until Alex's death 10 days later?
Yes, it did.
Bless you. Did Derek ever leave bruises on your arms?
Yes.
What generally would cause those bruises that you're aware of, Josie?
I feel like I always had bruises on my arms from him grabbing me.
Okay, so he demonstrated that on me yesterday. Would he grab you by the arms or by the biceps?
Yes.
What would he do when he grabbed you by the arms or the biceps?
He would pin me to the wall or pin me down to the bed.
And I'm not going to redisplay the photograph, but do you remember the photo of Alex's arm with the bruises on it?
Yes.
Do you have any idea how Alex would have gotten those bruises on his arm?
He would grab him by the arms, drag him around.
Okay. So, Josie, in some of those videos that we saw earlier, is it fair to say that you would yell at him too?
At Derek?
Yes.
Yes.
Is that something you're proud of?
No.
Were there points in time in your relationship where you felt like you had the strength to speak up against him?
There was points where I didn't. There was points where I tried talking, and then there was points where I escalated and I would yell.
Was that ever a good excuse for Derek to hit you?
No.
Would the kids sometimes see this arguing between the two of you?
They've seen it a lot.
Josie, are you claiming in any respect that you always behaved perfectly towards Derek?
I didn't.
Now, since you've been arrested and charged, where are Brantley and Araya living?
Brantley and Araya are with Derek.
Have any idea what Derek or members of his family are saying to Brantley and Araya?
I have a lot of ideas.
You don't, since you're not there, do you know?
No.
I want to talk a little bit about that video of Brantley that was shown at the beginning of this case where he came in and said, Dad hit me on the head, and he goes like this. Do you remember that?
Yes.
Were you telling Brantley to make that up?
Absolutely not.
What do you remember? Did Brantley come in and report this to you?
Yes, Brantley had accidentally knocked the TV down in the room. They were jumping on the bed, watching TV. And Derek hit him over the head.
Was that an example of Derek telling the kids what to say to the authorities when he said that Mom's lying?
Yes, he always said that.
Did you see that video of Derek questioning Brantley in the bathroom?
I did.
How did Brantley look to you in that video?
He looked scared.
You recognize that look on your little boy when he was making those statements?
Yes.
And was that normal for Derek to do, to question the kids, to get them to say what he wanted them to say?
I've seen it a lot with Brantley and Alex, where he would hold the phone over their face and record them and tell them what to say.
So he'd stand over them with his telephone and record them saying what he wanted them to say?
Yes.
Josie, I want to talk to you a little bit about your interactions with Alex, and I'm going to play a relatively mundane experience from after Alex broke his leg. Would you ever take Alex with you shopping when you went to Walmart or grocery stores or anything?
Yes, a lot.
Is that because you did the majority of the shopping for the house?
I did.
And if we can get the Elmo up, please. Judge, these will be going on Defense Exhibit 203. The video is labeled 48 Josie Entrance 12723 1247.avi. This is a material that was provided to us in criminal discovery. The video is, this one is, I believe, 27 seconds. Offer the exhibit and move to publish.
Objection.
Received, publish.
Okay. Josie, did you have a chance to see that video from January 27th at Walmart?
Yes, I did.
Was that you pushing the two kids in the grocery cart?
Yes.
Who were the kids in the grocery cart?
Alex and Araya.
And it looked like they had a bag of food open. Is that right?
Yes.
What food was that?
I don't Pringles or snacks. I don't know.
Like Ritz crackers, maybe?
Maybe, yeah.
Why would you have gotten a bag of food out for Alex?
Because it keeps shopping, makes them hungry. It keeps them occupied.
Okay. Was that something that you did pretty commonly for the kids when you took them to the store for shopping?
Yes.
It looked like Alex and Araya were smiling in that video. Is that right?
Yes.
Were they generally happy to go shopping with you?
Yes, and sometimes they would help me because all the colors and all the activity overwhelms my brain at the store, and I'd make it a game to where I'd look up items that I was getting on my phone and they would help point it out, and after they helped me at the store, they'd get a treat.
Okay. Was that pretty regular for you?
Yes.
So Alex is riding in the cart. Why is Alex riding in the cart?
He had a broken leg.
How did you get him into the cart?
I carried him. Or no, he had his walker.
Okay, and you helped lift him into the cart?
Yes.
I'm gonna go to the second video here at the checkout line. For the record, Judge, the video is labeled 49-Josie transaction 12723/1300.ABI, which I would stipulate means 1:00 p.m. We'll be adding this to 203. Offer the exhibit, move to publish.
Objection.
Okay, receive, publish.
See that video, Josie?
Yes.
And before we go any further, were you able to see the Ritz Cracker logo on the bag when it was in the?
Yes.
So looks like it's checkout time, and looks like you were struggling a little bit with the scanner at the checkout line.
Yes.
And I noticed that you bought some Red Bull. Is that correct?
Yes.
Did you and Derek drink a lot of Red Bull?
I did.
But what's happening with the sucker? It looks like Araya comes over and has a sucker in her hand.
Yeah, she ran and got a sucker, and I made her go back and get one for Alex.
Is that why there were two suckers?
Yes.
Do we actually see Alex get his sucker?
Yeah, she went and gave it to him, and then he handed it back to me to open it, and I told him to wait until we get to the van.
Why did you insist that Alex get a sucker as well as Araya?
Because whatever she got, whatever one kid got, they all got.
Looked like the kids were happy and playing at the checkout line. Is
Yes.
that a normal experience for you with Alex and Araya?
Yes.
Josie, I want to talk to you a little bit about the forensic interviews, and I'm going to ask you if you agree with some of what was said. What was your reaction to Brantley claiming Alex?
That was something that they did. They all did. They seen Derek do.
Did you kick Alex?
No, I did not.
Did you ever joke with the kids about discipline that you would do if they misbehaved?
I mean, when several times I'd ask them, to settle down or quit roughhousing or stop jumping on the couch, or I'd say, do you want your butt spanked? But I'd never do it. And that's why they kept roughhousing and didn't listen, because they knew I'd never do it.
Did you say it in a joking tone?
Yes.
Josie, I can't believe I have to ask you this, but did you keep poisonous water in the drain of your shower?
No.
Aware of any poisonous water at home?
No.
Did you have a secret door in Zayden's room that contained diamonds, guns, and a paddle to hit the kids with?
No.
Was there any Other than maybe the cubby hole upstairs, was there ever any secret door?
No, and that was never Zayden's room.
Was there ever any diamonds? Was
No,
there ever any paddle?
no,
How about guns?
no, I don't like guns.
Josie, did you make Alex pick up dog poop on his broken leg?
Never. No,
Did you ever make him pick up dog poop on his broken leg?
no,
Let's clear the air right now on Wayne Colkind. Did he stay overnight for a period of time at your home?
yes, there was a really bad winter. It was really, really cold out, and he was sleeping outside, and it was a couple days that he stayed in our basement.
A couple days, meaning 2?
Yes,
Was that close in time to the time frame that Alex died?
it was before, way before.
Did Wayne have a dog?
Yes,
What happened with the dog's poop?
I made him pick it up. I told him if he had the dog there, he had to clean up after it because I didn't want the kids stepping in it.
Did he clean the dog poop up?
Yes,
Did the dog ever poop inside?
no,
Now, did Brantley have an active imagination?
he did. A very active imagination.
You guys tell each other stories or come up with silly stories to tell each other?
Yes, him and Alex and Araya.
Was it common for him to come up with stories that involve things like poison and diamonds and other things that you know to be untrue?
Yes,
Sustained.
Let's talk a little bit about Major. We've heard a little bit about this already, bless you. But just describe your relationship generally with Mark.
we did not get along
Did you have to go to court with Mark?
several times. There was constant custody battles.
At some point before Alex died, were you given sole custody of Major?
Yes, I was.
And was that a source of anger or resentment between you and Mark?
It was not. It was because Major came to my house with a phone from Mark.
We can't go into that. But was Mark upset with you because of you getting custody of Major?
He was very upset with me.
Who took Major after Alex died?
Right after I found Alex on the floor, my mom was on the way to drop off Major to his dad's when I had called her, and after that, he kept Major. He didn't drop him back off.
So he went to Mark's family effectively?
Yes, and Mark was having supervised visits at the time, but he didn't bring him back because he seen all the ambulance and everything at the house.
So when Major said that he saw you kicking Alex, did that happen?
No,
Did you ever see Major doing any of the things to Alex that he attributed to you?
yes, Major was very mean to Alex.
Can you explain that a little bit?
Major had very violent issues, and I was taking him to counseling for that.
I'm gonna object to this.
Overruled.
Did you ever see him kicking Alex?
I did.
How about choking?
I have seen him choke Alex.
Is that something that you felt was appropriate when Major was doing that?
Absolutely not. I was trying to get him help.
Is that why you took him to see the Mr. Island?
Yes, and Major was very upset with me for that.
So, Josie, I'm going to ask you, do you claim at all to be the perfect parent to these kids before your arrest?
I was not the perfect parent, but I tried to show them love.
Do you claim to be the perfect partner to Derek during these?
No, I wasn't.
You agree that you struggled to keep up with keeping the house tidy?
Absolutely. I did.
Do you agree that you and Derek struggled with the kids' attendance?
Yes.
Are you willing to acknowledge your own flaws as a parent and a partner as you sit here today?
Absolutely.
To make any excuses for them?
No.
Leading up to your arrest on May 19th, were you aware at that time that you were a suspect in Alex's death?
I knew I was. I had been told I was.
Who told you that?
Detectives and CPS.
Did Derek talk about it as well?
Yes.
How did you react, Josie, when you were arrested for Alex's death?
I was in shock. I didn't understand
What didn't you understand?
why I was being arrested for something I didn't do.
Were you trying to forget elements of those days leading up to Alex's death at all?
I was not trying to.
Was it something that you felt comfortable thinking about, remembering Alex's death?
No, my brain is, with all the trauma I've taught myself, it has trained itself to shut down and in trauma events block out the trauma to protect itself.
Have you had some time since this whole matter started 3 years ago to begin putting the pieces together?
Yes,
When did you learn the official cause of death for Alex?
when I was arrested in a jail cell.
And before that point, did you know the full extent of Alex's Xanax levels or his injuries?
I did not,
Do you believe that Alex had a good life?
not with his father.
Had you hit, harmed, choked, or physically assaulted Alex in any way on February 10th before he died?
No,
Was this something that you ever did to him?
no,
You feel like you would have even been physically capable of doing this in that time frame?
no, and my heart would never do that. I loved him with all my heart.
Who was the only person that you noticed hurting Alex on February 10th?
His father, Derek Pedron.
Who was the only person on February 10th that you saw in possession of Xanax?
His father, Derek Pedron.
Did you ever give Xanax or something you believe to be Xanax to Alex?
No,
Did you kill Alex, Josie?
no.
How do you feel about Alex right now?
I miss him every single day and I love him with all my heart.
All the questions I have.
Ross?
I'm gonna start with where counsel left off. You found out about the cause of death for Alex the day that you were charged, correct?
Yes,
You had the criminal complaint that told you all the injuries that Alex had.
yes,
You also had the toxicology results, correct?
I believe so.
Who's the first person that you called from the jail after you were arrested?
My children.
The first person that you called was Derek Pedron, isn't that right?
Yes, my children were with him.
And the first person that you called after finding out all this information was Derek Pedron, and you told him you loved him, didn't you?
I did.
You told him you loved him multiple times on that call, isn't that right?
Yes,
At the end of that call, you actually asked him, why aren't you saying you love me back, right?
I don't recall.
You wanted him to say that he loved you too, right?
I don't remember the exact words.
You told him on that call, you got what you wanted, I'm charged, right?
Yes, because
No, it's a yes or no answer. They can clarify with you, okay?
yes,
Now, when you said you got what you wanted, never once on this jail phone call did you say, Derek, you're the one that did this.
Objection, calm down, silence. Represented.
It's on a jail phone call and it's before.
Okay. Overruled.
no, I did not.
Never once did you say, Derek, you got me into this trouble, right?
No,
Never once did you say, Derek, you caused abuse to Alex on the evening of February 10th, right?
no,
Never once did you say, Derek, you're the one that brought Xanax into this house. You never said that either, did you?
no,
This is after you had all the information and you are sitting in jail knowing that you've been charged with these offenses. You call Derek Pedron, first person you reach out to.
my kids were on the phone.
And you asked Derek if he's going to allow you to talk to the children after he knew that you had been charged, right?
My kids were on the phone. Yes,
The kids were on the phone because Derek said he would allow you to talk to the children. Isn't that right?
he didn't clarify if I could continue to talk to my children.
He allowed you on those phone calls to talk to your children, correct? You talked to your children.
Yes, that was the last time.
And you couldn't talk to your children anymore because of other court proceedings, right? It wasn't Derek preventing the contact.
He said I manipulated them on that phone call because I
You
asked if they
manipulated
were safe. Yes,
Now, you prepared for your testimony with your attorneys, is that right?
I seen my attorneys. Yes,
They prepared you for testifying in court, correct?
I practice. Yes,
You practice. Attorney Zachar always has a very nice binder with all of his questions in an order and what she's going to ask them, isn't that right?
yes.
And you knew the order because he went over those questions with you before you came into this courtroom, isn't that right?
I did not know the order.
He used that binder when he asked you the questions when you were practicing, right?
Yes.
And how many times did you practice with Attorney Zachar? Was it one time? Was it more than one time? Many times?
It was every week.
It was every week.
Yes,
Every week since 2023, since you've been charged, you've been practicing with Attorney Zachar for the moment that we saw yesterday and today,
not. I wouldn't say every week since when?
since he's been on the case.
No.
You practiced quite a few times with him,
Yeah,
You rehearsed quite a
multiple
few times.
times. Yeah, I was scared. I was nervous.
over 10 times,
With my brain injury, I needed to.
over 20 times.
I don't know the exact number.
It's quite a few, isn't it?
There's multiple times.
And so you knew the general order of the questions that were going to be asked of you, isn't that right?
It's the truth. Yeah.
This past weekend was Mother's Day, isn't that right?
Yes.
The day where we celebrate the women in our lives that put children first, correct?
Mothers who have children.
Yeah, sustained. Not sure how that has anything to do with it.
In 2011, you failed Haley, isn't that right?
I did.
In 2013, you failed Haley, isn't that right?
Yes.
And in 2011, when you failed Haley, you said she fell down the stairs leading to a traumatic brain injury, isn't that right?
She did.
And there was no safety gate in the house, correct?
It was broken.
It was broken. You didn't get another one, correct?
I believe I did.
You believe you did.
Yes,
And you
I
weren't
did.
using it?
I did.
You did. Then it wasn't being used by you.
Yes, it was.
It was being used?
Yes.
So she fell through a safety gate, according to you?
I'm saying after that.
After that, you got a safety gate. Okay. And that's a failure on your part as well as Mr. Barnes. Isn't that right?
Yes.
The fall occurred when only you and Haley were home.
Yes.
And other than Haley, who was not able to talk at the time, you're the only person that can say what happened to Haley. Isn't that right?
Yes.
In 2013, you failed Haley again, didn't you?
I neglected her. Yes.
She went from the 80th percentile weight to the less than 6th percentile while in your care.
In our care.
You're in Mr. Barnes' care.
Yes.
You're both responsible.
Yes.
You both failed her.
Yes.
She was losing hair.
He was.
She was injured with a broken bone in her foot.
It was undated when that happened.
I didn't say that. I said she had a broken bone in her foot. You agree with that?
A healed broken bone.
Her leg was swelling to the point that your own mother took her in, right?
Yes.
Because she couldn't walk.
I don't know if she couldn't walk.
You were a caretaker for her at the time.
Yes, that was several years ago.
You talked about on direct examination yesterday the fact that Mr. Barnes was not working and you were working during that time frame, correct? You remember that testimony?
Yes.
You were working less than 5 hours a week.
I picked up shifts when I could. It varied.
The evidence is that you were working less than 5 hours a week.
It depended on the week.
But for the most part, you were working less than 5 hours a week.
Judge, I'm going to object. That's an answer.
It's not answering the question.
The answer said that it varies.
Assisting.
You spent most of the day yesterday, roughly about 5 to 6 hours, talking about Derek, correct?
I don't recall how long.
A lot of your testimony has dealt with Derek and Derek's violence, isn't that right?
Yes.
Perhaps not even the last hour of your testimony talked about Alex in the last moments of Alex's life, isn't that right?
I did.
I'm going to object to mischaracterizing. I think we brought that up well before the last hour.
The jury knows. They have their notes.
You know, move on. That's been asked and answered. Go on.
You would agree with me that the vast majority of your testimony has been talking about Mr. Pedron.
You asked us already. Move on.
I want to talk to you a little bit. Yesterday, we talked a little bit about the dirty underwear in the bathtub, correct?
Yes,
And you said that if you see the dirty underwear, you throw it away immediately.
I do.
You throw it away immediately. You're not going to deal with it again, right?
No.
Okay. And you attributed the dirty underwear to Mr. Pedron, isn't that right?
Yes, he.
You also said that there was a bottle related to urine in the same bathtub, isn't that right?
Yes.
Okay. And you also attributed that to Mr. Pedron, isn't that right?
Yes.
We saw on body cam when law enforcement arrived, you were wearing black pants and a red sweatshirt, isn't that right?
Yes.
Can I have the ammo, please?
Are these already admitted or which is
Yes, they're already in there.
Oh, yeah, sure.
This is exhibit number 96. This is the bathtub, correct?
Yes.
This is the dirty underwear,
Yes.
and this is the bottle you were talking about? down here?
Yes.
That's what you're talking about, right?
Yes.
Okay. And you attribute those things to Mr. Pedron?
Yes.
Okay. And you're sure about that as you sit there today?
Yes.
State's exhibit, excuse me, this is defense exhibit 254. What are you wearing in this?
A robe.
A robe, correct?
Yes.
A bathrobe, correct?
I used it every day, every night.
When you were texting with Raphael at approximately 9 p.m., you said, I just took a shower.
I believe I said I was going to take a shower.
Are you sure about that?
I'm not sure. I thought that's.
If your
what I
text
said.
message said, I just took a shower, then you would be mistaken. Isn't that right?
Can you show me?
Yes, I can. Now, let me just ask you this question. You would not take a shower in a tub with dirty underwear in it, right?
Absolutely not.
You would not take a shower with a bottle that had urine of your child in it either, correct?
No.
If there's a time differentiation of about a half an hour when you stop texting with Raphael, and then after that you return and you say, I just took a shower, that'd be consistent with you taking a shower, isn't that right?
I don't believe I did take a shower because there was dirty underwear in there and I didn't want to clean the tub. I didn't feel good.
Why would you tell Raphael you took a shower if you didn't take a shower?
I was flirting with him.
You have a bathrobe on consistent with taking a shower.
I never used my bathrobe after I took a shower. I used towels. I used my bathrobe to stay warm. I didn't feel good. I still use a bathrobe in the house, walking around.
State Exhibit 146. I'm showing you page 12. Can you read this message from you to Raphael?
Yes, it says I just took a shower.
I just took a shower, meaning you just took a shower.
Yes,
That's what you messaged him.
it
You
is.
would not take a shower in a bathtub with dirty underwear or that bottle, correct?
Right, meaning I did not take a shower.
You just told him you just took a shower.
Right,
Those are your words.
yes,
So are you lying to him about it?
I
Are
was.
you making it up now because it doesn't fit what you told this jury yesterday?
Objection, argumentative.
Sustained.
You told this jury yesterday that the dirty underwear were from Mr. Pedrin, the bottle was from Mr. Pedrin, correct?
Right,
And you
it
told this
was.
jury yesterday that you would not stand for underwear, dirty underwear, or that bottle being in the shower. You would get rid of it immediately.
If I was changing a child, I would get rid of it. I didn't feel good that day and I did not want to deal with the dirty underwear and cleaning that shower.
The shower isn't just one message with Raphael. You guys talk about a shower quite a bit, isn't it?
I don't remember.
Because Raphael says to you when you're talking about the shower, he says, I want to shower with you.
Yes,
And then you continue on having a conversation with Raphael about how many dates it will take before you have sex with Raphael or shower with him. Isn't that right?
yes.
And you say it's going to be at least 4 dates.
Objection, relevance.
Sustained, I'm not sure. The shower thing is relevant.
The
Overruled.
sexual activity is not.
It's context, Judge. These are her statements.
Okay, I'm going to overrule the objection, but move on. Is there more?
Yes.
Okay.
I did not take a shower that day.
You're telling us today you did not take a shower, even though your words that day say you did.
Right,
Because that one fit with what you told this jury already.
Objection, argumentative.
Sustained.
I didn't tell them I took a shower.
No, your messages did.
Right,
You're the one that changed Alex Xavier that evening, correct?
no. I
Put him in his pajamas.
didn't change him. I put pajamas on him because Derek did not.
You put pajamas on him.
Yes,
Those were fresh pajamas and clean pajamas, correct?
they were what I found in a pile.
They were what you found in a pile.
Yes,
You inspected those pajamas.
I did not feel good. I grabbed pajamas and put them on him.
You're aware that in the bedroom where Alex Xavier and you went to sleep on the evening of February 10th, 2023, there is an empty container of cotton candy.
There,
Characterizing the bedroom.
She says it's her bedroom. How is this mischaracterizing it?
In the kitchen in the photographs.
It's not.
there may have been another.
147, it's right there.
Yeah, I mean, we haven't had testimony on it, but yeah.
Okay, it's been marked as 147. This is your bedroom, right?
Yes,
You see an empty container of cotton candy right next to your white.
I do. I don't know what color it was. There was pink, there was blue. I don't know what color that one was.
You don't know what it was, pink or blue?
Right.
The label would indicate that's both, right?
No, it doesn't.
Are you familiar with that brand?
At the bottom, it looks pink.
It looks pink.
Looks like there's still some in there. It looks pink at the bottom.
There's cotton candy remnants all over the floor of that bedroom. Isn't that right?
We don't know what that was.
You don't know what it was?
No, we don't know what that blue substance was.
It's all over in different spots in the carpeting. Isn't that right?
We don't know if that's cotton candy.
There's a blue substance all over the floor, in the carpeting, in the floor of your bedroom, correct?
We also played with Play-Doh and we had magic sand.
I understand you're saying it's not cotton candy. There's a blue substance all over your floor in your bedroom, correct?
There was, but we don't know what it was.
You don't know what it was.
Neither do you.
There's also a blue substance on his pants, correct?
Yes,
Consistent with him getting into whatever blue substance is on the floor and in your bedroom. Isn't that right?
Yep.
Argumentative speculation.
Overruled.
that blue substance could have came from something they ate another day.
It came from another day. It also could have come from when he was only with you, right?
We don't know.
We don't know. We would know if you kept a better eye on him, wouldn't we?
Objection, argumentative.
Sustained.
It's your job to watch him 24 hours while he has this broken leg, correct?
Objection, speculation, argumentative.
She said it.
Overruled.
We were sleeping.
You're supposed to keep 24-hour supervision on Alex Xavier with his broken leg.
He was in my bed and we went to sleep.
My question is, were you supposed to keep 24-hour supervision on him?
I was, and he was in my bed.
He got to your bed because you moved him from the couch that he was on to the bed. Is that right?
Yes, I wanted him closer.
And the path that you would take to move him from the couch in your bed to the side of the bed that you put him asleep on, would be right past any objects that would be on the floor.
There's a lot of objects on the floor here.
There was an open path, though, where you could walk and put him out of bed, right?
I don't know about open. There's a lot of stuff on the floor.
There's a lot of stuff on the floor. I'm gonna ask the detective, Sergeant, investigative sergeant, Emmons to help.
Judge, I'll note for the record that it appears that the state is applying forensic protocol here, and that Sergeant Amundsen has placed a sheet of evidence paper on the floor and appears to be reopened exhibit with fresh gloves.
Thank you.
I would note that the bag that was reopened, the chap's bag, appeared to strike the side of the wooden paneling of the court's raised bench area.
The record should reflect that State Exhibit 110 is now on the floor in front of the defendant. It's in between the court reporter station and the jury box. Do you see the bag on the floor?
Yes.
That's the bag that was on the floor on the morning of February 11, 2023, correct?
I don't remember exactly where it was.
You don't remember where it was?
Not exactly where it was, no.
You didn't move it between the time that you called 911 and law enforcement arrived on scene, correct?
No.
All right, so wherever law enforcement found it, that's where it was, correct?
Yes.
And you're aware that it was photographed and captured on the floor next to the bed, correct?
Yes. I mean, wherever they photographed it or wherever they found it.
I want you to look at the size of the bag that's in front of you.
See it?
That bag, you're saying that was out the evening of February 10th, 2023, when you took Alex Xavier from the couch, would have had to move past this bag and put him on the bed. You're telling us you would never have noticed this bag on the floor.
I didn't.
You didn't.
No.
You didn't because it wasn't there, right?
It was wherever they found it. I mean, I had plenty of, if I would have seen it in my walkway, then I would have seen it. It was not in my walkway.
You got
I'm sorry,
to answer the question, then ask your question.
Judge, for the record, the bag is placed horizontally facing towards Ms. Dikeman, not vertically. The width of the bag is at its widest.
That's fine.
Do you have a picture of where it was placed? Then I can better tell you.
It was admitted into evidence. I don't have it from you right now.
Well, that doesn't help me then.
This bag is noticeable on the floor right now as we sit here, right?
I need to see where it was.
My question is this noticeable right now on the floor as we see it right now? Yes or no? Yes or no?
I need to know what's in the room.
That's what we need a picture. It's captured on body cam, so I'll cover that a little bit later.
Okay.
I'll agree with that. There was a photograph of the bag where it was found, if that helps move this along.
Yeah, could you tell me which photograph it is?
No, it was one of the state's exhibits.
Come back to it. I want to talk to you about the timeline of that evening into the next day, okay? Derek makes a phone call to you at 5:19 p.m. before he arrives home, isn't that right?
Before he arrives home from work?
Yes, 5:19 p.m. Derek calls you.
Okay.
You guys talk for approximately 5 minutes.
Okay.
You agree that Derek got home around 5:30 in the evening, is that fair?
I believe so.
Okay, tell us exactly what Derek did when he first walked in the door.
He went by Alex.
You went in by Alex?
Yes.
And did
I was not in there, but I know he went in right in my room.
you went right into your room right by Alex?
Yes.
Then what happened?
Then I went upstairs by Jalen and I heard noises. For sure. So I waited and I was talking to Jalen and then I heard him again and I came back downstairs.
So if you heard noises, it's safe to presume that Jalen would have heard those same noises. She was right next to you.
I'm not Jalen, I don't know.
She was near you though, correct?
She was.
And describe the noises that you say that you heard and you're not sure if Jalen heard or not.
I heard screaming.
Screaming.
Yes.
It was screaming so loud you could hear it upstairs.
Yes, Jalen had her music on YouTube and I still heard it.
So Jalen would have heard these screams too.
I can't say what Jalen heard.
It was so loud you could hear it over Jalen's music.
I heard it.
Major was downstairs, correct?
Yes,
Major was in his bedroom, correct?
he was.
Major was in his bedroom right next to the bathroom, correct?
He was.
And the screams that you say you heard upstairs in the second floor were loud enough to hear throughout the house. That far away.
I heard it upstairs.
Okay. And so if you could hear it, presumably Major certainly could have heard it.
All the domestic violence that happened in that house, Major was always in his room and he never came out. He would avoid it.
That wasn't my question. My question was Major would have heard it if you could have heard it upstairs.
I'm not Major.
Sustained. She doesn't know.
What?
Can we get the forensic evidence off the floor?
Yep, it can be picked up, please. Unless you're going to use it for some other reason.
No, that's fine.
Yeah.
Judge, you want to take just like a 5-minute break so I can be, otherwise.
I'm just like, we need to clean that up, maybe find some other things. Yeah, let's take about a 5-10 minute break here. Let's say 10 after.
Is it 5 after, Judge, or 10 after?
10 after. You may step down. Thanks. All right, 10 after.
Are we still on the record? I just want to put the.
Hold on a second. Okay.
All right.
Yeah, go ahead.
I observed Sergeant Amundsen place a new pair of gloves on his hands. He's now placing the chaps bag back into the previous evidence bag. My concern with this is that the bag was in the line of speaking of both Mr. Torbenson and Ms. Dikeman and potentially the jurors, where if there's going to be airborne contamination, it was right in that zone where that could happen.
Okay. I'm not too worried about that.
It's important to note this for the record, Judge, in case this ever needs to be tested.
I would just, then I think it's important to note my distance away from it, which is well over 6 feet. Studies show that it's extremely rare, if not possible, for DNA to travel over 6 feet.
Okay. We'll see you at 10 after.
Thank you.
I'll lock down the office.
Make sure you don't do that until.
I take it her head started hurting. Ooh, my neck, my back. I ain't even gonna see the rest of it. Y'all know what I'm talking about. Her head hurting. She gotta get off the stand. Okay, here we go. Y'all know we fast forwarding through this stuff.
Medication that she's had a pre.
That before the jury came in, before or after the last break, Mr. Torbenson was still speaking about alleged drug transactions that the court found to be inadmissible, and I saw the door open and I saw the first juror coming through as that discussion was happening. Just putting that on the record.
Okay. Maybe we should talk about that issue since it's been brought up. I'm not the conversation, but you wanted to bring further information to the record. Go ahead.
Because the argument that I have relative to that is it's drug-seeking behavior on the part of Ms. Dikeman. She's seeking a specific medication that she's had a previous addiction to, and she's admitting to the police that she's seeking it from Mr. Colkind. The text message exchange that the defense admitted regarding Mr. Pedrin, there's no demonstration that that's a completed drug transaction. In fact, it's just the opposite, because the person says that's a long 10 minutes, and that's the long message. So there's no indication that that's a completed transaction, yet that was allowed in evidence. This is exactly the same as that type of conduct here. It's drug-seeking behavior on the part of the defendant, which I think is arguably even more relevant, because in those text message exchanges, it's someone else seeking drugs from Mr. Pedrin, not Mr. Pedrin seeking drugs from somebody else. Here, it's her seeking a substance she was previously addicted to, wanting to pay for it, and she has testified on the stand that she does not seek or use outside of a prescription.
Judge, that wasn't her testimony. She admitted to that repeatedly on direct examination. We've introduced evidence of that. The court already, I thought the court had already ruled on the Ed Colkind issue, as I would have addressed that in my direct. I thought the court made a ruling this morning indicating that it wouldn't be proper fodder for cross-examination. The difference between Ms. Dikeman and Mr. Pedrin is that Ms. Dikeman has constitutional rights here. Mr. Pedrin is not entitled to the same right to a fair trial, to the same inferences as any suspect. It's redundant. It's not in response to any question that Ms. Dikeman asked. Saying that she had drug-seeking behavior tells us nothing at all about whether or not she killed Alex in 2023, if she sought out oxycodone or whatever in 2019. It's irrelevant. It's prejudicial. It was previously barred just this morning by the court's order. I'm asking the court to exclude it.
I'm going to keep my order as I made that order based on what I had. Let's just keep moving. I don't think that's a make or break huge issue here, but it is. I know it's yet another potential impeachment concept for the possible impeachment, not concept, but possible impeachment by the state. It's ambiguous with Mr. Colkind. I don't want to make much of a comment on this, but there is a question about constitutional rights. It is correct, Ms. Dikeman has an absolute constitutional right, well-established constitutional right to a fair trial. More up in the air on the issue of how mercy's law involves the victims of cases. So, but that there is definitely a tension between those two things. I'm just going to leave it at that. There's not a lot of clarity about where those lines are drawn. Let's just move on.
I wasn't going to address that point, Judge.
Okay,
Address something
another issue? Okay.
Defense had a very long direct examination with the defendant over yesterday into today. And all I'm going to note for the record is the court has very quickly been shutting me down on questions. And the defense went over and over topics again and again and again to the point that it was utterly repetitive. I've only been questioning her for not even an hour. And the quickness with which you are sustaining objections relative to what they went through and the time I have relative to them, I just want noted for the record.
All right.
Judge, sorry to keep bringing up new.
I am not treating the state any differently than I'm treating the defense. I find that just a little bit, there are asked and answered questions that are asked repetitively. I'm trying to sustain those because it seems like everybody's asking variations of the exact same question. And I am not, I listen to the question, I listen to the objection, I respond. I don't take a tally of when I've done this for one side or the other. In fact, I'm not being any quicker other than trying to keep the trial going. So having said that, what's the other issue you want to bring up?
Judge, I was just handed what's been marked as State's Exhibit 149. It appears to be yet another summary of phone activity. The summary has not been authenticated through another witness. It has not been disclosed to us before now. We've had no opportunity to check this for accuracy. If the state intends to use this as an exhibit, I would object. It's not authenticated.
This is a phone summary of what?
It's from directly authenticated records, and it contains no content other than the timing in which things happen. And it's a conglomeration of all the records from text messages, phone calls, which are all from very different records, but they're all certified records.
They could have introduced that through the actual custodian who's introducing that. This hasn't been authenticated. I haven't been able to check any of this.
You're going to use it right now?
I want to use it. There's a time frame where there's no activity, and I want to talk to her about that with regards to this.
Right. We're not going to get through the cross anyway at this point in time. Chances are we'll have to go into the afternoon. It's going to give the defense an opportunity to look at that. If there are some issues with it, we'll bring that to the jury's. If there's problems with how it's written down, like it's wrongly done, we can bring that to the jury's attention. For right now, let's move forward. I understand. I'm allowing either side to use summaries on this discovered evidence that's out there. So if there's discovered evidence, you do a summary to make it move forward. I'm allowing that to happen. The state's just done a few more of it in this trial. That's all. So
yeah, and just for the record, my objection here is authentication and confrontation.
Okay. All right. Okay. As far as authentication goes, if there is a problem with the sequence, that will be brought to. Yeah, this is a problem. She's not the custodian of the records. The more I think about this,
they've agreed to authentication. That's
okay.
That's happened.
Thank you for that. That helped. They've agreed to authentication.
We agreed to the authentication of the Cellbrite downloads. We did not agree to the authentication of the summaries that we're getting at, in the middle of cross-examination.
The base data has been agreed upon. What is in the fact that there's a summary, if it's badly summarized, the defense can go into that or have the ability to take it apart. If it's something that you look at the authenticated documents and the authenticated documents do not support the summary, we will bring that to the jury's attention. Okay. So having said that, let's bring the jury in. All right, everybody may be seated. Go ahead.
Ms. Dikeman, I'm going to show you what's been marked as State Exhibit 149, which is a summary that I prepared from your records, okay? I want to show you a text message that you sent to Mr. Rafael Suarez at 7:47 in the evening on February 10th, 2023. Do you see that entry right here?
Yes, I do.
Okay. The next message or the next entry on this chart is from Mr. Rafael Suarez sending you a text message back. Is that correct?
Yes.
And that is at what time?
8:05.
8:05 p.m. on February 10th, 2023. Is that correct?
Yes.
The next time that you respond in any fashion to Mr. Suarez is what time?
8:29.
8:29 p.m. Is that correct?
Yes.
So from 7:47 p.m. to 8:29 p.m., you are not messaging Mr. Suarez, correct?
Correct.
You're not making a phone call to anybody, correct?
Correct.
It doesn't show any activity on the part of your phone during that time frame. Isn't that correct?
Correct.
And all of that would be a time frame before you sent a message saying, I just took a shower. Isn't that right?
Yes.
You had a number of phone calls that day. We talked about the first phone call that you made, or that Derek made actually to you, which is before he came home on February 10th, correct?
Correct.
At 6:49 p.m., did you have a call with your mother?
I don't know the exact time, but I probably did talk to my mom.
Your mom was coming to pick up the 2 older children that evening. Is that correct?
Yes,
Your mom did, in fact, come and pick up Major and Jalen that evening, right?
she did.
And that was after the 2 of you talked about that, correct?
Yeah, we would have talked about it.
Your mother, Miss Ehlers, came into your house to pick up the children.
She did not come in the house. I don't believe she did.
You don't believe she did?
I don't believe she came in the house.
Okay. If she made a statement otherwise, you wouldn't know that, correct?
Objection calls for hearsay.
I'll withdraw it. You don't recall her coming in the house?
No,
You don't recall her seeing what the children were doing or anything like that, or having a conversation with her?
no, I don't. The kids always went outside when she got there.
You had a phone call with your mom at 9:38 p.m.?
I may have.
It lasted about, I'll show you, 2 minutes and 52 seconds.
Yeah, looks like it.
Now, this is the same evening that you're saying that Derek just beat Alex Xavier, correct?
Yes,
You're having a phone call with your mother that's approximately 3 minutes in length, right?
yes,
You're concerned about child abuse that's happening in your home, right?
it happened a lot.
That wasn't my question. My question was, you're concerned about child abuse that's happening in the home, correct?
Yes,
Okay. And you don't say anything to your mother in this 3-minute phone conversation about any concerns relative to Alex Xavier, do you?
no,
You don't say a single word.
no.
You don't report anything that's just happened. I'll move on. That's not the only phone call that you had that evening, is it? Did you have a FaceTime chat with Laura Lee?
I'm not sure if it was FaceTime, but I talked to Laura Lee.
Talked to her twice, right?
It would have been by phone call, I believe.
Let me show you your records. Your records indicate that you had a 13-minute Facebook call with Laura Lee,
Yeah, call.
and that would be after 10:30 in the evening, correct?
Yes,
And then you had a second phone call at 10:44 with Laura Lee,
yes,
and that lasted 16 minutes and 43 seconds.
yes,
So you had 2 phone calls with Laura Lee that approximate 26 minutes in time total, correct?
yes.
And during neither of these phone calls, do you mention anything about Alex Xavier being in any way physically harmed by Mr. Pedron?
No, I didn't.
You didn't mention it at all.
No,
You didn't mention anything about how he appeared to you or concerns regarding Alex Xavier, isn't that right?
no,
And in fact, in that second phone call, that's when Alex Xavier can be heard saying, I'm waiting for you to go to sleep so I can get into things, right?
that's not what he said.
What did he say?
He said yes.
Today you're saying he said yes, but in previous interviews, you said, I'm waiting for you to go to sleep so I can get into things.
I
right?
never said that.
You never said that.
No,
You were interviewed by Investigator Williams on body cam, and you told Investigator Williams that's what he said on body cam.
I told him, I asked him, and he said yes.
You told him you asked him, and he said yes.
Yes,
Okay. And today you're saying he said yes, not yes, right? You're drawing out the yes as though there's something wrong with him, as you say it today.
I thought he was being silly.
But he is being silly.
Yes,
So when you say yes like that, you're not trying to indicate today for the first time that there's something physically wrong.
Mischaracterizing. She gave that testimony yesterday.
Okay, I'm gonna allow you to ask the question. Go ahead.
When you are using your voice in that manner to stress how Xavier sounded to you for the first time in trial, you're saying that that was silly to you.
well, my voice doesn't sound exactly like his did, but he did prolong his yes.
But you took it to be silly, right?
I thought he was being goofy. He was
Nothing else
also-
wrong with him.
He was playing with his hands in the air
As he laid next to you,
as he laid a couple kids away from me, yes.
according to you.
That's the truth.
You watched the forensic interviews of Araya, correct?
I did,
You watched the forensic interview of Brantley, correct?
yes.
Both of those children said that they did not sleep next to you on the evening of February 10th, 2023, correct?
Not in their initial interview.
In their initial interviews, they did not say that they slept next to you, correct?
They didn't say anything about sleeping with me.
They said they slept upstairs.
Judge, I'm gonna object to your saying if we can get a definition of which video we're talking about or which bit of testimony we're talking about.
Can you identify which statements you're talking about?
Sure. In Araya's forensic interview, she talks about sleeping upstairs and being awakened by Brantley. Isn't that right?
I believe she was confused with me telling her to go upstairs.
You believe she was confused when she made those statements?
Yes, as it was for me, that was a very traumatic event for her.
And when Brantley was interviewed, Brantley said that he was asleep upstairs.
I don't believe he said that in his interview. He said that on the stand.
He said that on the stand as well.
I don't believe he said that in his interview. You can see in the picture I took, he was by me in bed.
At 9:15, correct?
He was by me the whole night.
The photograph that you took is at 9:15 p.m., correct?
Right, and that makes sense that he stayed by me. Why would he go upstairs?
To go to sleep would be one reason, right?
He was going to sleep at 9 in my bed.
You said to this jury that the children go to sleep in bed with you because of Mr. Pedron. Mr. Pedron wasn't home that evening, isn't that right?
And it doesn't change that they would go upstairs. You've seen how messy it was.
Exchanged well over 100 messages with Mr. Suarez.
Correct.
You described during your interview that at some point you tried to shut off the TV around 11:30 to midnight, correct?
Correct.
And you described that Alex Xavier was not going to sleep and wanted to stay awake, right?
He was still moving a lot, yes.
And so as a result of that, you turned the TV back on.
I did.
And you and Alex Xavier continued to watch TV.
I'm not sure if he was watching, but I continued to have the TV on and watch it, yes.
You were still texting during this time frame, correct?
Yes.
In fact, your text messages were pretty consistent with Mr. Suarez throughout that evening.
Yes, I was excited for the date.
Your text messaging Mr. Suarez as early as 6:15 p.m. or 6:18 p.m., correct?
Yes.
What was the time of your first message with Mr. Suarez?
6:18.
6:18 p.m. Is that is it you sending a message to him or is he sending a message to you?
I sent a message to him.
Sent it to him. And you would agree with me that between 6:18 p.m. and midnight, you exchanged a number of messages with Mr. Suarez.
Yes.
Close to, if not over 100. Would you agree with that?
Probably.
You'd agree that in not one of those messages did you express any concern with regards to Alex Xavier or his physical condition?
No, my mind was on my date, and Derek had told me he did not hurt Alex in there, and I didn't think it was that severe that Alex had internal injuries. If I did, I would have gotten him help.
You send Mr. Suarez a photograph of law enforcement outside of your residence, correct? From your camera system?
I may have.
And after sending him that message, you said there were up to 5 members of law enforcement that were at your house to get Mr. Pedron, isn't that right?
I'm not 100% sure.
You also told Mr. Suarez that Mr. Pedron was violating the no contact order, didn't you?
I believe so.
Okay. So you told him about the no contact order, but you didn't raise any concerns relative to Alex Xavier, correct?
Like I said, I didn't think Derek hurt him severely.
That wasn't my question. My question was...
No, I did not.
You did, right? You could tell him about the no contact order. You could tell him that police were present, but you didn't tell him anything regarding Alex Xavier being hurt, did you?
No.
And you have told us a number of times that you care about Alex Xavier, right?
I loved him with all my heart like he was my own, yes.
I think you said at one point during direct examination, if you could replace yourself with Alex Xavier and have him here and you not here, you would want to do that, right?
I would in a heartbeat, yes.
That's how much you love this child.
Yes.
That's how much you want to protect this child and keep this child safe.
Yes.
And you had this information regarding him allegedly being assaulted in the bathroom, and you don't tell Mr. Suarez, do you?
Section asked and answered.
Go ahead. That's the question again.
I know him like that.
You had this information that he allegedly assaulted him in the bathroom, and you didn't tell Deputy Paff when he came to the residence.
I didn't feel like I could.
You had this information, and you didn't tell Deputy Kernan when he was at the residence.
I didn't feel like I could.
You had Deputy Paff's personal cell phone number on your phone.
I didn't feel like I could. My life was threatened.
Mr. Pedron was arrested and removed from your house, correct?
That didn't stop him.
That wasn't my question. He was arrested and removed from the house, right?
Yes.
He was in law enforcement custody, correct?
Yes.
You know at that moment in time, Mr. Pedrin can't do anything to you, correct?
Yes, he could.
While he's in custody?
Yes.
You don't call Deputy Paff, do you? You don't report anything to Deputy Paff.
No, I didn't feel safe.
You didn't report anything to Deputy Kearney.
I didn't feel safe.
You didn't report anything to then Sergeant, now Lieutenant Williams, correct?
I didn't feel safe.
You had Lieutenant Williams' number in your phone.
I didn't feel safe.
You had the ability to call Lieutenant Williams.
I didn't feel like I could.
You had the ability to call him. You had the phone number, you had a phone, you had the fingers.
I had their numbers, yes.
You chose not to.
I didn't feel like I could.
When you observed Alex Xavier after Mr. Pedrin left, you told Sergeant Williams that he was actually getting better after he woke up somewhere between 7:30 and 8 o'clock.
He wasn't puking.
He was what?
He was not throwing up anymore.
He was not throwing up anymore. You said he appeared better to you, not just not throwing up. You said he appeared better, right?
When I moved him from the couch to the bed, he was not throwing up anymore. And I asked him, "Are you feeling better?" And he shook his head, yes.
You told us earlier that you picked up McDonald's for the children. Do you recall that
Yes.
testimony yesterday? And I believe you told us that Alex Xavier didn't really eat anything, but he drank his soda. Is that right?
Yes.
And the soda that you gave him because he was sick was a Sprite. Isn't that right?
Yes, I believe so.
Okay. And a Sprite doesn't have caffeine in it. You're aware of that, right?
It could have been something else. I don't know.
It could have been something else.
It could have been a different kind of soda. I don't remember all the details.
Yesterday you told us it was Sprite, though. You said
I
Sprite.
thought it was, yes.
Okay. And today you're saying, after hearing that he had caffeine in his system, it could have been something different.
I know I gave him ginger ale that night, and I'm pretty sure it was a Sprite. Sometimes the kids took a drink. I always had Coke in my cup, and the kids were always known for taking a drink of my soda.
So he maybe took a sip of your soda. You're saying
Could
that
have.
too? Alex Xavier was in bed with you from after the two children are picked up by your mother until you decide that you and he are going to go to sleep. Isn't that right?
Can you repeat that, please?
Sure. What time did you go to bed with Alex Xavier? And when I say go to bed, I mean go physically lay down. I don't mean go to sleep.
We all went to bed when Derek got arrested.
When Derek got arrested?
Yes.
That'd be after he left the house?
The kids were laying down.
So you went to bed before you're sending a message about, I just took a shower?
I was laying down at that time.
I'm just asking you, did you go to, are you telling us today you went to bed before sending a message saying, I just took a shower?
Yes, I was laying down.
When you put pajamas on Alex Xavier, you saw his body?
It was dark in the room.
What room did you put pajamas on Alex Xavier in?
My room.
Your room?
Yes.
You agree that Alex Xavier was not complaining about in any way, shape, or form during that time that you put pajamas on him, correct?
He was not.
He was not complaining of pain before that either, was he?
His stomach hurt.
From throwing up and being sick?
He didn't specify.
You could see Alex Xavier's face during this time frame, right?
It was dark in the room.
TV lights up the room a little bit, right?
A little.
You could see enough to recognize the children in bed with you?
Yes,
You could see enough to recognize their faces?
I could. I knew which child was which.
You could see enough to know whether or not there were any visible injuries on the face, right?
I mean, yeah,
And you didn't see any visible injuries on his face other than that old scab, right?
right.
No bruising around his eye?
No, bruises can take time though.
I understand that. I'm just asking you what you saw. You didn't see any bruising around his eye, right?
No,
Bruising on his head,
no,
bruising on his arms.
I didn't really examine.
You said you didn't complain of any
He
pain
was,
though during this time frame, right?
no,
He's acting normal to you.
I mean, he didn't feel good. He seemed like he didn't feel good, but he wasn't throwing up anymore.
He wasn't lethargic, right?
He was thirsty.
Can we get the state to define what lethargic means to us?
I don't know.
That was the answer earlier. Go ahead, or question earlier. Go ahead.
You know what the word lethargic means, right?
Thirsty?
He didn't appear tired to you, right?
Yes, he did.
He did.
Yes.
He's staying up and watching TV with you until 3 o'clock in the morning, but he appears tired.
I mean, he was like out of it more, thinking back.
Thinking back, as you said, charged today.
As time went on, thinking back, wasn't himself.
You never reported that to anybody who interviewed you, did you?
I only did one interview.
Correct. You only did one interview. That's
Yes.
true. With law enforcement, you talked to a lot of other people. You talked to Laura Lee, right?
Not much.
Talked to your mother.
Not much.
You didn't report any of these circumstances that you're telling us about today to any of the other people in your life, did you?
I didn't talk to many people. I pretended to be okay so that my children would be okay. Because that's what their counselor told me to do.
That's when your children are around, right? Pretend to be okay when your children are around you.
Right, and I cried at night while watching them sleep because I was scared one of them would die.
That recommendation doesn't apply to when you have a conversation with another adult, though, right?
I didn't talk to adults. I didn't talk to anyone.
You told us yesterday in direct examination that you would tell Laura Lee almost everything that happened when Derek would assault you.
Not after Alex passed.
You would tell Laura Lee everything that happened before Alex passed, though, right?
Yes.
You would send her countless videos.
Yes.
You're aware that your Google return only shows one video being sent to Laura Lee from you, correct?
I had other emails.
You have other emails?
I did, yeah. I
You're aware
used
that
other
Laura Lee
phones.
says you only sent one video to her.
I sent her more than that. I had another phone with another email.
I want to talk to you a little bit about the SD card that you said you had. Do you recall that yesterday?
Yes.
You said you had an SD card that was a treasure trove of evidence regarding Mr. Pedrin abusing Alex Xavier, correct?
I did. I had a SD card in another phone.
SD card and another phone.
Yes.
And you said that there was a theft at your mother's house, correct?
Yes, there was.
No, that was your testimony yesterday. There was a
Yes.
theft. There's a theft at your mother's house, correct?
Yes.
And you told us yesterday that there was a backpack that contained this SD card that was stolen during that May 17th theft at your grandmother's house or your mother's house.
There was the phone, the SD card, and my key fob. Yes.
You never reported that theft or any theft taking place at your mother's house, isn't that right?
I did.
The only theft that you reported was the break-in of your Suburban that was at the house on OS, isn't that right?
I did. And I didn't realize how he got into my vehicle until I noticed my key fob and the phone was missing.
I want to talk to you about the report that you actually made to law enforcement, because yesterday you said this happened at their house. The report that you made regarding a theft was to your old Suburban at the house on OS, correct?
Yes.
And the only things that you reported to law enforcement in that theft report was that the car radio was stolen. Isn't that right?
The TV deck was stolen out of my vehicle at my house, but at my mom's house, my key fob was stolen to get into my Suburban, and my phone and the SD card was taken out of my backpack.
You never reported anything to law enforcement about an SD card from your backpack, isn't that right?
I didn't know those were taken until I noticed my key fob and the phone was missing, and that was
Called law enforcement
after
to follow up and say there's additional items that were taken.
I got arrested.
At some point you were released, correct?
I was.
Could have made a phone call then, correct?
I didn't have any of my stuff. It had all been taken.
You had the ability to make a phone call even while you were in jail, isn't that right?
I think that wasn't on my mind anymore after fighting for my life.
You sent text messages to Mr. Pedrin after this took place, isn't that right?
I might have.
You sent text messages to Mr. Pedrin telling him that you loved him.
Yes,
You sent text messages to Mr. Pedrin telling him that you missed him.
I did.
You sent text messages to Mr. Pedrin saying that you wanted to be with him.
I did.
There were also times that you used these videos as a way to get Mr. Pedrin to come over to your mother's house, isn't that right?
It wasn't as a way to get him to come to my mother's house.
There was a time where you gave Mr. Pedrin a countdown. You said he had an hour to come over to the house to start, right? Do you remember?
Yes.
And then you said he had either 40 or 30 minutes to come to the house?
Yes.
And you wanted to have sex with Mr. Pedrin this evening, isn't it?
That wasn't.
And you were telling Mr. Pedrin that if he didn't come over, you were going to send the video to the police.
It wasn't worded like that.
You said you were going to release the videos.
Yes, but it wasn't due to the countdown. It wasn't either you come over in an hour or I'm releasing the videos. Those are two different occasions.
You're sending the text messages to Mr. Pedrin, and you're also saying, I'm going to release the videos during the same time frame. Isn't that right?
It could have been, but it wasn't worded in that way.
He never came over, did he?
I don't know.
Those messages indicate that you had the ability at that point in time, if you wanted, to send those videos to law enforcement. Isn't that right?
I don't know. I was scared of him.
You're scared of him. During this time frame, you also had an attorney that was representing you relative to the children. Isn't that right?
Yes, but
And that was relative to custody of the children. Isn't that right?
yes,
Who should have placement, who should have visitation, while this matter was being investigated further. Isn't that right?
yes,
And you had videos, you're saying you had videos that demonstrated that Mr. Pedrin was abusive towards the children, right?
yes, and I talked to him about that.
And you had the ability at that point in time to take that SD card, that information, and turn it over to your children so that he didn't have access to the children. Isn't that right?
Objection, Judge. I think we're getting into attorney-client privilege with Mr. O'Neill.
I'm asking about the ability. I'm not asking what was discussed.
But I mean, the response there, if we wanted to corroborate or disconfirm, would be to waive for attorney-client privilege.
Right, sustain.
You never chose to share the videos with anyone in that fashion, did you?
I talked about it with my attorney.
There's a guardian ad litem that also represents the children, correct?
Did.
During that action, there's a guardian ad litem that represents the best interest of the children.
Yes, there was.
And they have the ability to look at that. You could share it with them, correct?
I didn't. They were all pointing the finger at me at that time.
Well, if they're pointing the finger at you, wouldn't you want to point that finger somewhere else, like you're telling us in court?
I tried.
I'm going to object. I think we're getting into comment on silence now. She had an attorney. She was represented. She had represented the police that she only wanted to deal with investigators through counsel.
I'm not asking about any contact with law enforcement.
Guardian ad litem's not law enforcement though. So let's move on to law enforcement. Go ahead. Did
you share it with the guardian ad litem?
No, I told CPS.
Did you share it with CPS?
No, I tried talking to them about his abuse and they shut me down.
So CPS just shut you down?
Yes.
I want to talk to you about the statements that you made to Deputy Kernine on the evening of February 10th. You allowed him in the house to see Alex Xavier, correct?
Yes.
You allowed him to inspect Alex Xavier's body?
I allowed him to do what he needed to do until Alex was scared.
And then you asked him to leave, correct?
Yes.
And Alex's expression of fear to you was not about Mr. Pedrin, it was about law enforcement being present, isn't that right?
I don't know if Alex understood that he was law enforcement. He had a bright light in his face and he said, "Mommy, I'm scared."
He recognized that it wasn't his father, right?
I don't know. I don't know what Alex thought at that time.
You told law enforcement that evening, February 10th, 2023, that Mr. Pedrin was just violating the no contact order, isn't that right?
I told them that I was scared.
I understand that you said that. You also told them that Mr. Pedrin was just violating the no contact order, correct?
I don't remember saying that to them.
Do you remember watching the videos in court?
Yes.
Okay. If all you said to law enforcement is that he was violating the no contact order when you're really telling us that he assaulted Alex, then you lied to law enforcement, isn't that right?
Objection.
No.
Calls for a legal conclusion.
She said no. Didn't lie to law enforcement. Go ahead.
You didn't tell them what you're telling us happened to Alex, did you?
I was scared. I didn't feel like I could.
Who's it more important to protect in that situation right there, you or Alex?
Alex, and I tried to.
And the way you could protect Alex is to tell the police exactly what you're saying happened, isn't that? That would protect Alex. Isn't that right?
No.
You've been interviewed a number of times by the police relative to domestic violence by Mr. Pedrin, isn't that correct?
Yes.
You've been asked the details about those assaults every time, isn't that right?
Yes.
Outside of the 911 call where you make a reference to Alex, not once did you tell investigators in those investigations that Alex was abused.
No, but when I did, they didn't do anything. And I got beat for it. And he threatened to kill me and the kids.
Not once in any of those investigations did you remember say anything about any of the children being abused, correct?
No.
These are situations where you are telling law enforcement about you being assaulted, so you feel comfortable enough to share what's happening to you, but you won't say anything about the children during any of these investigations. Isn't that right?
I did, but I didn't want him. I didn't know if he would kill us.
You thought it was safe enough to say something about you, but you thought Mr. Pedron would kill you and the family if you brought up the children?
I thought he'd kill me and the family every time I called, but when he would get to the point where he would escalate to the point where I thought he was going to kill us, I would call. And those times I called, I had the opportunity to call. I didn't always have that opportunity.
And in those situations where you did call, you never once, outside the 911 call we listened to, brought up abuse to the children. Isn't that right?
No.
And these are children that you're telling us today that you would put before yourself if you could to save them.
I would.
Asked and answered.
Sustain.
The video that you had and you sent to Laura Lee, you didn't send that to law enforcement, did you?
No.
The van video.
No.
You sent it to Laura Lee with what instructions?
To keep it.
To keep it. To keep it until you decided that it should be shared?
In case I needed it.
Didn't you need it the moment it happened? If you're saying that was abuse to Alex by Mr. Pedron?
Clearly I was weak and felt trapped. She could have helped me and sent it to law enforcement.
So it's her fault.
No, I'm saying I needed help.
Did you ask her to send it?
No.
Your instructions were for her to hold it and keep it, right?
Yeah.
And she listened to your instructions as far as you know, right?
Yes.
Just maybe this is a good place to break for lunch.
Yeah, if you have another section. Okay, let's have a lunch break. We'll be back at 1:15. Please don't talk about the case. We'll see you then. Can we just take a break? See you at 1:10.
Thanks.
Thank you.
Yours, Matt.
Sorry. 447.
To show the consistent communication, those are all recorded in the phone as selfies, and those are the entries I did not include because I don't think that they're being sent to anybody or being done. Maybe they are being sent to somebody and I didn't include them, but those are the entries where there's no, in my mind, no communication taking place. What I included is communication with individuals, and that's what's captured in that exhibit.
Well, it also includes internet search queries and other non-communication data.
So was the point of it, of the summary, was to show inactivity at certain points?
is to show her activity, her phone activity in terms of phone calls, texting, using Facebook, or sending photographs to someone else.
And if I understand what the sort of the purpose of the exhibit is to sort of show there's gaps of opportunity, is that possibly, I'm right, wrong about that? I could be wrong.
It's to show the consistent communication with Rafael Suarez, the text messages, the number, the nature, the phone calls that she had with individuals during the relevant time frame, the text communication she had with those individuals, to show the gap right before she said she had a shower where there's no communication on her part for about a half hour to 45 minutes. That's the purpose of the exhibit.
But are there selfies and Google searches and stuff like that going on during that gap?
There are selfies being taken by her on the phone, but they're not, I didn't include the selfies unless they were sent to somebody.
No, I'm talking about the gap.
Yes, there's some small gaps where she's taking a series of selfies and then she picks which one she wants to send to Mr. Suarez.
You're not, so there's this gap which the state is alleging she went and took a shower. So the question is there anything in that period?
There's nothing in that gap, Your Honor. Okay. Those numbers are consistent.
All right. So this is what we're still going to have a little bit more time. I'm not going to exclude it for that reason at all. As long as it's consistent with what's there. I do think it was used more about the question of communication. In other words, that there was a lack of communication of critical Alex Xavier being harmed during that time. Seemed to be what the questions were about. So that summarizes the communications that were going on. Is that a fair statement, Mr. Torberson?
Yes.
Yeah. Okay. And that's what it's summarizing. It's not summarizing the actual, she's looking up Google searches or anything of that sort at the time.
Which time gap are we talking about here? Because there are a number of number skips.
The time gap that I asked for was entry 231, which is, I'm sorry, it's entry 233, which is text to Rafael Suarez. The very next entry is 234, which is text from Rafael Suarez. That's at 8:05, but her next response is until 8:29, which is 2:35. So there's no gaps in any cell phone activity from 2:33 to 2:35.
The times were 7:47 p.m. to 8:29 p.m. Right. I believe those are the times. You may not have the same times or it should be the same times.
Should be. And all those records came from Exhibit 121, I believe.
Yeah, these were the Cellbrite records that you had.
Yeah, I mean, same objection. We haven't had a chance to check any of this for accuracy, but I understand the court's ruling.
Okay. Anything else, Mr. Zachary?
No, Your Honor.
Okay. So we can bring the jury in, State?
All right, why don't we give Ms. Dikeman back up there?
Sorry, Ms. Dikeman. Why don't you come up and have a seat? Go from there. All right, let's bring the jury in. Okay, and everybody may have a seat, and we'll continue. Go ahead, Mr. Toberson.
Good afternoon, Ms. Dikeman.
Hello.
Ms. Dikeman, there was some conversation about Wayne and a dog. You remember that?
Yes,
With your attorney? And you mentioned that Wayne had not been at your house for a long time, and when he stayed at the house with the dog, it was because it was really cold. Is that correct?
yes,
You're aware that there's messages between you and Derek just the week before the death of Alex Xavier, where you're talking about Wayne staying at the house, correct?
I don't remember when that was, and I'm not 100% sure when Wayne stayed at the house.
And Wayne was helping or staying at the house because he was helping you buy a new car, isn't that right?
He did help me get a vehicle, yes.
And the time that you needed a new car was right around the time of Alex Xavier's passing, isn't that right?
It would have been around the time of Alex's leg break, yes.
Showing you State's Exhibit 150. Is this messages between you and Mr. Pedder?
Yes,
And it's referencing Wayne and a discussion about Wayne.
yes,
And there's a message from February 6th of 2023 where you say he's staying again because he's helping me buy a vehicle. Is that correct? It's about 2/3 of the way down.
on February 6th, yes,
You see that message?
yes,
That confirms that Wayne and his dog were staying with you during this time frame, correct?
I believe that was the last night, yes.
Okay. I move 150 in evidence.
Judge, again, it's an older document. Action.
It'll be received.
You were shown a exhibit yesterday, 300 by Attorney Zachar, that referenced a message that you sent to Mr. Pedron that Alex needed to be home and healing with you and not getting drunk and high with Mr. Pedron. Remember that message?
Yes.
Okay. I'm going to show it to you right now. It's Defense Exhibit 300. This is the one that we're talking about, right?
Yes.
Now, that's just a very small snippet of that chat, correct? It's really 2 sentences.
Yes.
Okay. What is the UTC time of those messages? Do you want me to read it? It might be harder for you to read it. I'll do it.
Okay.
And then you can tell me if I'm right or wrong. So I'm going to read from right here. It says UTC 2203:54. Do you see that?
Yes.
And UTC means that we subtract 6 hours during this time frame. So that would make it 16:03:54, correct?
I'm not sure about that.
And thank you. I was hoping someone would. And that would make it 4 o'clock in the evening. Okay. Exhibit number 7 is Mr. Pedron's time card. Now, this is happening on January 19th of 2023. Here's the entry on exhibit number 7 for January 19th, 2023. Tell the jury what time you clocked out.
It says 5:10.
5:10. So you are messaging him about getting drunk and high, and he's actually at work.
He had people clock him out all the time. His friends would clock him out of work.
That's your accusation.
It's true.
Those records say that he was at work, correct? You agree with that?
It says he was clocked in work. It doesn't mean he was at work.
Let's talk about what the additional messages say that also weren't shown. I'm going to show you State's Exhibit 151. There were just 2 text messages that were contained in 300 from the defense. This is the larger portion of the conversation. Would you agree? Absolutely.
I'm sorry, what's the exhibit number again?
151, Your Honor.
Thank you.
I want to direct you to the last 2 messages at the bottom of 151. Do you see it? You can compare it to these 2 messages so you can show that I'm showing you the exact same message chain. And what I've handed you is Defense 300. For now, Ms. Dikeman, you can just stay on page 1. Do you agree that the last 2 messages in Defense Exhibit 300 are at the very bottom of State's Exhibit 151?
Yes.
And yesterday, you were only shown the 2 messages from Defense Exhibit 300. You weren't shown the rest of those messages. Is that right?
Yes.
Now, if you go up a little bit on State's 151, you can see a sentence where you say, you are already complaining about the Jenna part. Do you see that?
Yes.
You're referencing Jenna Love. Isn't that right?
Yes.
Jenna Love is Alex Xavier's mother.
Yes.
And Jenna Love was about to get out of prison during this time. Isn't that correct?
Not for a couple months.
Okay. You had some rules that you wanted Mr. Pedron to follow, or you weren't going to stay in a relationship with him.
I wanted her to stay away from me.
You wanted her to stay away from you, no contact with you, right?
Yes.
And you wanted no contact between Mr. Pedron and her as well. Isn't that right?
Away from me and my children.
Away from you and your children. You
Yes.
didn't want him having contact with her either, though.
That was left up to Derek.
Do you recall Derek sending at your request a text message to Aubrey, his daughter, saying any contact with Jenna would have to go through third parties?
I don't know what Derek did.
Okay. He sent that message or screenshot to you to prove to you that he wasn't going to have contact with Jenna because you didn't want that contact. Isn't that right?
I don't see that.
It's not in this part. It's just before this part. I'm asking you if you remember all this.
No.
Do you remember having 3 rules for Derek?
Where's that?
I'll show those to you in a little bit. Now, in this message chain, the very next line after the 2 messages that you sent and we talked about in Defense Exhibit 300, You say, I gave you the option to make it right, and instead you want to call obsessive over Jenna and scream at me only about that situation. You see that on the second page?
I didn't get to read the second page. You told me to stay on the first page.
Okay, second page, it's the very first entry. Let me know when you're done.
Yes, I see it.
See it? What's the very next line that you sent him in that very same message? Why don't you read it out loud?
It says it's just like you to only care about Alex and not Brantley and Araya.
So you're telling him he only cares about Alex and not the other two children.
Brantley and Araya always felt left out, yes.
Your very next message to him is one day they will have a man in their life who actually cares about them, right?
Yes,
So you're sending this to a man that you're afraid of, and
yes.
you're telling him that his children are going to have a different man in their life.
Brantley would always ask me if I could give him a better dad.
I'm going to ask that that be stricken from the record. That's hearsay.
But she was responding to your question, so I'm not going to strike it. Go ahead.
Turn to the next page, page 3 or page 36 at the top of that exhibit. The fourth entry down, you say, that's why all you do is say that you and Alex are leaving. Do you see that?
Yes,
Followed by you saying you don't give a fuck about me or my kids.
yes.
You believe that Derek gave preferential treatment to Alex.
I believe that he left the other kids out when he would use Alex as a pawn.
And yesterday, when you were testifying about this text message exchange, you said you didn't want Alex leaving the house with him because you thought he was going to be drunk and high when he had Alex in his care. Is that right?
He was.
Okay. The very end of this exchange, you tell you're having Derek sent to your mom's house to pick something up for you. Do you see that? Derek sends you a message that says, I will call you when I'm by your mom.
Objection, hearsay, confrontation.
I think that's the effect on the listener, but what she's going to respond to. Go ahead.
And that's what it says.
That's what it says, right?
Yes.
And you actually sent the passcode to your mother's house for him, correct? So that he could get into the house? And actually, it's on a different exhibit from the next day, so I'll show that to you.
It says, and I'm sick of you throwing Alex in my face. Really, why should I care anymore?
I'm going to show you what's been marked as 152. This is a continuing exchange between you and Mr. Pedron, is that correct?
What page?
I'm going to show you the very last part of 152, which is a screenshot. What is the screenshot of?
It's of my mom's messenger.
And it's a message that you are forwarding to Derek with a passcode to get into your mom's house. Isn't that right?
Yes, but it just says that Derek's stopping by.
You're sending him to stop by. Isn't that right?
Yeah, it could be for anything.
Pick up things for you.
Yeah, I don't know what.
You said earlier that Derek and your mom don't get along at all, correct?
There was times where they did, but for the most part, no.
Okay. So this person that you're saying is drunk and high during this time frame, you're sending out in a car to go pick things up.
Judge, I'm going to object. I think that mischaracterizes this is from the following day.
I don't know what the, is this one continuous day? It's unclear to me.
One into the next.
Into the next
Ongoing
day?
conversation, yes.
Right. The next day, I don't know that he was drunk or high.
This is the 20th is the day of the party, right?
Of Laura Lee's party?
No, the party that you said he had people over at the house.
Yes, but what time was that?
This message is sent at 0027:31. Subtract 6 would be
6:27 p.m.
6:27 p.m. You're sending him over to the house.
Right, and I don't know who was driving, and I don't know. He
That's the
could.
day of the party, where he had people over at the house.
I don't remember exact dates, but if it lines up with the messages, then yes. But I don't know when he started the party.
Okay. I want to talk to you a little bit about Dr. Endres' evaluation of you. She said one of the things when she evaluated you and your personality is that you project blame on other people. Do you recall that?
I do recall her saying that.
And that you minimize your role or responsibility in things? You recall that?
I don't recall that.
Okay. When you were talking under direct examination yesterday, you said that you talked to the children about the basement stairs, the children being the children that lived with you in the house on OS, correct?
I don't remember saying I talked to them about the basement stairs.
You said you don't recall that.
Can you,
That's by just yesterday that you
can you
talked to the children.
explain more about that conversation?
Yes, you talked to the children about those stairs being unsafe and they shouldn't play around them.
Yes.
Okay. That's not enough as a part of a parent to secure those stairs and make them safe for a child. Is that right?
They were old enough to walk. They were old enough to know yes and no and understand not to play by the stairs.
So Araya should have understood as a 4-year-old child not to play by those stairs. In your mind.
Relevance.
You can ask if Araya was old enough to understand.
As you can see in the interview, Araya was a very smart child and she was very well spoken and she could communicate very well.
Okay. So you think that was enough as you as a parent to take safety steps for the children in the home, was just to tell them, hey, those are dangerous, stay away.
Yes, and that is why I told them to throw their clothes, not bring them down the basement stairs.
Same thing with prescription medication. You had a conversation with the children and you said, these are mom's prescriptions, stay away, don't touch, that's for adults.
Since my brain injuries, the kids noticed that I would always take pain medications or a lot of medications, I should say, not pain. And they would ask me, Mom, what are those? Why do you always take medicine? And I would tell them, Mom has to take them because of my head. You know how Mom always has headaches because they were used to quiet time. You know, Mom's head hurts, we have to have quiet time.
My question is that you believe just telling kids.
Explaining why we had about the medication, why I explained to them.
I'm asking you beyond explaining it to them, should you have taken other safety steps?
That's not what you asked. You asked if I had a conversation with them, and I'm explaining.
Beyond having a conversation with them, should you have taken other safety steps with your medication?
Objection, speculation, relevant. No. Calls for a legal conclusion.
It does not.
Overruled.
I had it in my drawer next to my bed where I took it morning and night, and I explained to them those are for Mom's head.
That bag of medication you had, you could have gotten rid of all those medications, couldn't you?
I planned on doing that, and then COVID hit, and we were on lockdown.
You could store them up high where no child could ever get access to them. You could have done that, couldn't you?
They were on a higher shelf.
They were on a higher shelf?
That's where I put them.
So they were on a shelf where none of the children could have accessed them, is what you're telling us today?
I believe they were either on that brown shelf or on my hanger shelf, which is where I put them.
And if they were on the hanger shelf, none of the children could have reached them. Is that right?
No.
That's not right?
That is right.
That is right. None of the children could have reached it, correct?
Oh.
So the only person that could have touched that bag was you or Mr. Pedron?
Correct.
The only two people that had the opportunity to touch that bag was you or Mr. Pedron, correct?
Yes.
Same thing if it was on the bookshelf, that was high enough that none of the children would access it, or no?
I can't say what the kids could have reached. I'm not the children.
You can observe how tall your children are and what they can grab, what their capabilities are, right?
Yes, but that house was very cluttered and I don't know what they could have reached. I mean, there was.
Whose responsibility is it to put things that are dangerous to children out of the reach of children?
I did.
You did?
I put it up. I believe it was on the hanger shelf.
You believe it was out of reach for the children?
I believe it was on the metal shelf where I hung up clothes. I believe it was on that shelf. That's where I remember putting it.
I want to talk to you a little bit about your interactions with the police on February 11th, 2023. On February 11th of 2023, Sergeant Williams comes and talks to you and you say that you want the no contact order dropped. Isn't that right?
Right after Alex died?
Yes.
Yes.
You said that multiple times that you wanted the no contact order dropped, right?
Yes.
Alex just died in the house.
Yes.
And at that point, you're telling us that you are searching for what could have happened to Alex to cause his death, right?
I thought it was an overdose.
I understand that's what you're telling us, but you're still searching for what it could have been, right?
In my head, I thought it was an overdose.
You wanted to provide information to the police that may be relevant to anything that happened to Alex, correct?
At that time, I thought it was an overdose.
I understand that's the rehearsed answer.
It's not rehearsed.
Just strike, asked and answered.
Struck, and it's also argumentative.
When you're having this conversation, you also bring up marijuana in the house, don't you?
Yes.
And you bring up marijuana in the house because that's a concern relative to something that Derek had, isn't that right?
Because he handed it to me before he went out to the cops.
Correct, because Derek used marijuana, right?
He did.
And that was what you would reference whenever you said Derek was getting high, was marijuana.
No, he used Xanax more.
You never told that to the police.
He didn't hand me his Xanax.
I didn't say you did. You never told the police about Xanax.
No, because he didn't hand it to me. I didn't have it. I didn't know where it was. He handed me the marijuana, so I felt like I had to tell the police because I knew where it was.
You knew the police were going to search your house. At that point, they had told you they were going to conduct a search warrant of your house.
Yes.
And actually, when they took your cell phone, they took it. You didn't voluntarily turn it over. They said, we're getting a warrant for your phone. Isn't that right?
No, he said I need to take your cell phone, and I handed it to him, and I gave him the password after I wrote down numbers.
Because he told you he was getting a search warrant.
I didn't care. I didn't fight him.
That's not my question. My question was, he told you he was getting a search warrant, right?
Asked and
I
answered.
don't recall.
You don't recall. You told this jury that you saw Derek Pedron do a line of Xanax on the table.
I did, yes.
At that point in time, you had to have a belief, if that's true, that there may be Xanax in your house when they're going to conduct a search warrant. Isn't that right?
I don't know what Derek did with his Xanax.
Exactly. You don't know if it's in the house or not in the house if you believe it's present, and you saw it previous evening, right?
I don't know what he did with his Xanax.
And the only thing that you mentioned as a concern when law enforcement told you they were searching the residence was marijuana.
Because I had had it in my possession.
We saw a number of videos through the course of this trial where Xanax and fentanyl were discussed by Derek to you, correct?
And I to him.
Correct. Those videos you never turned over to law enforcement, isn't that right?
Objection. Comment on silence.
At any point.
Comment on silence, Judge.
Yeah, he can't comment on our silence, but did they turn over? That's the question.
Did you ever turn over those videos to law enforcement at any point in time?
I gave them to my attorney.
Okay. Those videos contain accusations made by Derek about you using drugs, correct?
They were accusations towards him using the Xanax because he was.
That was your response to him, but Derek always accused you of using Xanax and he accused you of using fentanyl, isn't that right?
He accused me of a lot of things.
On those videos, he accused you of using Xanax and he accused you of using fentanyl, isn't that right?
Yes, and other things.
Those were the drugs that he brought up every time, isn't that right?
And other things, yes.
And you were wearing patches during this time frame. You've already told us about that, right?
Occasionally I wore nicotine patches.
You're telling us they're nicotine patches, but these were what Derek would say to you, Xanax and fentanyl, correct?
Argumentative, asked and answered, speculation, and
I'll move on. You knew that if you turned these videos over to law enforcement, they would have questions to you about your drug use, correct?
No, they could have drug tested me and I was working with an attorney and I handed them over to my attorney.
These videos were made in 2020 through 2022. You were not working with an attorney then, correct?
I was being advised by an attorney, yes.
In 2020 to 2022,
Yes.
you were providing these videos to an attorney.
No, I was being advised by an attorney to remain silent and not work with law enforcement.
Regarding what?
Regarding Alex's death.
From 2020 to 2022, you were advised to remain silent about the death of Alex?
He
didn't die until 2023.
I'm sorry, I get mixed up with the dates.
Okay. So you weren't advised at that point, correct? You agree with me now. 2020, 2022, Alex is alive.
Yes.
Okay. And Derek is talking about your drug use in these videos. He's talking about you using Xanax, you using fentanyl, right?
objection. Here's a confrontation, asked and answered.
I'm trying to get her focused, Judge, on the answer.
So the question, what I'm allowed to ask is, did she turn over those? You've asked this couple of
No, I didn't.
You did not turn them over.
No,
And you knew that if you did, you would be examined for drug use issues. Isn't that right?
I don't know.
You were asked about the school records for the children during your questioning yesterday. You agree that Alex Xavier had approximately 100 absences over a period of 2 years.
As well as the other children, yes.
He had more than the other children, though, correct?
I don't know.
You agree that Derek bears responsibility for that. You agree with that, right? He's the father. He should be getting Alex Xavier to school.
Yes.
Okay. And you agree that you also have responsibility for that, correct?
Yes.
You both have responsibility.
Yes,
Okay. And you both failed to get Alex Xavier to school on a regular basis.
I did. I couldn't.
We were shown 5 emails between you and the school. All those emails were from 2021 to 2022. Isn't that right?
I get mixed up on dates, so it's whatever they say.
They were from when Alex Xavier was in kindergarten. Does that help?
I know there was emails from first grade as well.
Okay. The ones that we were shown were from kindergarten.
Okay. There was one email from when he was in first grade.
One from first grade?
Yes.
Okay. So that's 5 messages that we were shown over the course of 2 academic.
We were shown a lot. I don't know the number.
One of the things that you said when we left off before lunch was that you were scared to say anything about Alex no matter what. You recall saying that?
I was scared to say anything about all the abuse, yes.
Okay. Even when Mr. Pedrin was in custody the evening of February 10th, you were scared to say anything to Sergeant Kernine, correct?
Yes,
Or maybe it might be Deputy Kernine, Deputy Paff.
yes,
You're scared to say anything to him, scared to say anything to Laura Lee,
yes,
scared to say anything to your mom.
yes.
Didn't say to anything to any of those individuals because you're scared, right?
Yes, I would cover up my bruises with stories.
One of the things you said on direct examination yesterday is that you were threatened with violence even if you talked to another man.
I was,
Okay. You said you were excited to be talking to Rafael Suarez.
I was,
You're excited to be going on a date with him.
I was.
You're excited about the prospects of starting a new relationship.
Possible, yes.
Okay. You weren't afraid of that at all, but you're afraid of disclosing child abuse
Yes,
to protect Alex Xavier?
to protect all of us, yes. Other kids were being abused as well.
According to you.
Argument.
It's the truth.
You saw the forensic interviews of the children, correct?
I did.
They didn't disclose any abuse by Mr. Pedrin, did
They
they?
were scared of him too.
Judge.
I didn't ask anything about the forensics.
The forensic interviews, you did bring up the forensic interviews. You mean, which ones, the 2?
I asked about disclosures regarding Mr. Pedrin right now. I think that's a different topic in the forensic videos.
Oh, yes.
And Judge, I think this calls for comment on the credibility of other witnesses, which is improper. I think that this is argumentative in the form that it's asked, as well as hearsay and confrontation.
It's an exception to hearsay. Counsel asked about the forensic interviews and her thoughts about the forensic interviews and disclosures on direct. I think it's appropriate.
No, overruled. Go ahead.
I said they were scared of Derek.
They were scared, so that's why none
Yes.
of them said anything.
Absolutely.
Okay. But they did disclose a lot about you.
Major did.
Major did, so
Yes.
did Brantley.
Brantley didn't.
He said you choke.
I don't recall what Brantley said, but
He said you hit.
I never hit Alex.
I'm saying what he said. He said you hit.
I never hit and I never choked my children.
He said you kick.
I never kicked my children.
The children were placed in separate homes before the forensic interviews were conducted and after the death of Alex Xavier. Isn't that right?
Yes,
Major was with his dad,
yes,
and his dad didn't live with you, right?
no.
He had no idea what or how you treated the children inside your home, correct?
They were all talking to Major before the interview.
They were all talking to Major.
His grandma and his dad were calling the sergeant multiple times after talking to Major,
About what Major was reporting, correct?
supposedly,
And you know those calls were recorded, correct?
to the sergeant,
Yes.
not the ones to Major.
And you know that the sergeant documented what those concerns were and they weren't relative to the forensic video.
Objection calls for evidence beyond this witness's scope.
Sustain.
You've heard those recordings.
I'll
move on.
Yeah.
Brantley was in a different home, correct?
Yes,
Brantley was in the home of one of your relatives.
yes,
It was your relative that took Brantley to his forensic interview.
yes,
Brantley, to your knowledge, was not having any contact with Major during that time frame, correct?
I don't know.
(153). These are the rules that you put in place for Mr. Becker. Do you recognize this series of text messages?
1 second.
Do you see about a little over 1/3 of the page down? It's a message from you and it starts off with the word fix.
Yes, are you gonna stop with the first, or start with the first rule?
Your first rule is fix the shit with no contact, correct?
Yes,
Okay. Your second rule is tell the truth. It's better for a family to communicate and you and her won't ever be. That's talking about her and Mr. Pedro and Jenna Love, correct?
I don't believe so.
And your option on that other one is, or tell me the truth, meaning tell me the truth about whether or not you're communicating with Jenna Love, right?
No.
Your next rule is get rid of bitches
All right.
because you thought he was seeing other women.
I didn't know.
And then the last one was make me feel loved, right?
Right. And not abused.
It doesn't say that. It just says make me feel loved.
But I know how I felt.
Your message is make me feel loved, right? He sends you a screenshot at the very end of this chain. I think it might be on your exhibit. I'm just turning it to mine so we can both look at it at the same time. The person in Mr. Pedron's phone is heart my life and then flowers, correct? At the very top.
I see it.
Yeah. And this is a text message to AUBZ, who's Aubrey, his daughter, right?
Yes.
And he's telling Aubrey that if there's communication when his mom gets out, there will still be a no contact order in place. Isn't that right?
Yes, that's what he says.
He's doing this because this is what you want.
No, I don't. I never controlled Derek. He controlled me.
He's sending you a screenshot saying that he's not going to have contact and telling Aubrey about that because that's one of your rules.
No, it was not.
Moving 153 in evidence.
Hearsay confrontation.
This is her messages, right?
To her message.
But no, it's a message that Mr. Pedron sent to his daughter that was screenshot and sent to her.
Okay. Okay. The earlier parts of the exhibit are received. The screenshot, screenshot is hearsay. But the screenshot is in reference to what the response is, so it's completeness unallowed to be received.
And my only argument would be it shows his actions based on the messages sent to him, sent back to her.
I didn't make him do
But
it.
I think that's the definition of hearsay.
That is the definition here. So I'm allowing it in just to show what the series of conversations are. So
yes,
and responses. Go ahead.
I want to talk real briefly about the chain of events surrounding Alex Xavier's fall down the stairs, as reported by you. Okay, that fall happened on January 14th, 2023.
I'm not good with dates, so
Okay, did it happen the day before or the day of the birthday party that you attended for Christian?
again, I'm not good with dates. That's the hardest with my brain injury.
Okay, if the birthday party that you attended for Christian was on a Saturday, you already represented to this jury that you wanted to get Alex Xavier medical care that Saturday at that party, correct?
I did.
And you also told us that it was Mr. Pedron who was drinking and wanted to stay drinking and did not want to get medical care for him, correct?
Right.
Okay, the next day is a Sunday though. And Alex Xavier isn't taken in for medical care at any point on that Sunday, is he?
I'm sorry, I do not remember the date. It's a blur.
Okay, he's not able to walk at all on Saturday. You have to pick him up and carry him, isn't that right?
I did.
Okay, and you had to carry him, not only just physically carry him out of the car, but carry him into the house.
Yes.
And you had to carry him and put him on a bed.
Yes.
And you told us earlier that you had balance issues, and so you didn't think you could do something like kick a child, but you're carrying around a 47-pound child.
It was very hard.
It's very hard, but you were capable of doing it, right?
I had to hold on with all my might,
And you carried him in that
almost
house.
dropping him. Yes.
And you carried him out of that house.
By the time I got to the vehicle or the bed, I was literally holding on till he was like to my knees. I struggled. The left side of my body is very weak.
And you could physically pick him up and put him in a grocery cart, correct?
Again, I struggled.
That's
And
higher up even to put a child.
If you can see where he was sitting in that grocery cart, it was on the seat, not in the cart. It wasn't in the cart. They had those double seats. So it wasn't like I was lifting him in the cart.
You picked him up and put him in the cart was my question.
Not in the cart, no.
You pick him up and carry him around the house.
No.
You moved him from the couch to the bed on the evening of February 10th.
Yes. Again, my right side is stronger than my left. So I
Yeah.
sacrifice my right side.
You have the ability to balance and carry a 47-pound child.
I sacrifice my right side a lot, and I used the bed to scoot him to where he was laying. I've learned to live with this disability.
Outside of sending one video to Laura Lee involving Alex Xavier being yelled at by his father and telling her to keep it and hold on to it and not send it out, Is there another example you have anywhere of how you protected this child from this claimed abuse that you say was being committed time and time again?
I sent over a dozen videos to Laura Lee.
That's according to you, not her though, right?
It's the truth.
With all this abuse happening to the children in the house, according to you, to Alex Xavier, to the other children, you never reported it to law enforcement once.
I did.
When?
On the 911 call.
You never reported it to police after making that 911 call. When you were interviewed, did you?
I did that one time. I felt like I could that one time. After that, I was scared for our lives.
Scared for your lives to report child abuse, but excited for your life to go on a date. Thank you.
Argumentative, move to strike.
Same. All right, redirect.
Josie, I want to talk about this issue with the shower. Back in 2023, how did you wear your hair?
I wear it either down or up.
Was it about the same length and, I was gonna say width, but the same fullness as now?
Yes, my hair's always been long.
Okay. How did you go about drying your hair after you get out of the shower?
I'd put it up in a towel.
So you wouldn't blow dry it right after a shower?
No,
And Josie, if you are in the shower, would you wash off makeup or other things that you were wearing?
yes.
I'm gonna show what's already been admitted as before. Josie, take a look at your hair here on the zoomed out view. Does that look like you had recently been in the shower?
No,
Does it look dry and like in the position that it normally would have been?
yes.
And I got a quick makeup tutorial over lunch from Ms. Sanchez here, but does it look like you're wearing lip gloss or something on your lips?
Yes,
Is that something that normally you would have washed off in the shower?
yes.
Zoom in here to your eyes, and it looks like you're wearing eyeliner on the upper and lower sections of your eye. Is that correct?
Eyeliner and mascara.
Mascara. Okay, mascara is the one on top, right?
That's the eyelashes.
Oh, okay, the eyelashes. Would you have put makeup back on after a shower?
No, not if I was going to sleep.
Josie, fair to say that there were some flirty texts about possibly taking a shower with Raph in the
Yes.
series of those messages?
Yes,
You're familiar with that bathtub? I have one like that myself in my house. Is it your experience that water or droplets of water will remain in the tub for a period of time after taking a shower?
yes.
And did you see any water or evidence of a recent shower in the tub?
No,
We're all addicted to our telephones these days. Are there parts of the day where you're not using your phone, Josie?
if I'm holding the kids to get them to sleep, Brantley was big on that. I had to hold him and rub his back. If I was watching TV, I would not. If I was eating something, I wouldn't. If I had a bad headache, because if I'm on the phone too much, I get the screen. I have to take a break.
How about if you're playing with the kids?
Yes. I stopped. One of the reasons, other than Derek accusing me of stuff, I stopped going on Facebook also because I noticed it was taking me away from the children.
Does it strike you as unusual at all, Josie, that there would be a period of time that you're not sending or receiving texts for half an hour to 40 minutes or however long that was?
Yes, I'm still like that. I won't text people back for a long period of time.
Did you take a shower?
No.
So going to after Alex died, did you want Derek to see the kids?
Yes.
Why is that?
I mean, I don't know why, but even being abused and going through all that trauma, you just, part of you wants that person there. And I just wanted a piece of Alex. I wanted a piece of, even though he was so abusive, I wanted to feel like Alex was there. I wanted to feel like that life was there. And even if I was getting beaten, I just wanted to feel like my family was there.
Okay.
Just for a second.
Was Derek seeing the kids regularly after Alex died?
He would not come see the kids. He would come in the night only to see me.
Were you upset with Derek for not coming to see the rest of his kids?
Yes.
Now, the state suggested that you wanted Derek to come over to have sex with you. Was that the case?
No, but that's all he wanted.
So, Josie, you were asked several times why you didn't mention child abuse before. Do you recall those questions?
Yes.
What were you trying to tell Sergeant Cernine when you told him that you were scared of Derek?
It was so hard to open up and talk to the police about what was happening. It's like I couldn't get it out because of the fear. And when I told him I was scared, part of me wanted him to just care and be there and ask, but I couldn't get it all out. The fear took over, and all I could see was what would happen if I did, what would happen if I told. He would find me. Pictures of the guns, people he knew would find me. He would kill me and the kids and then himself.
Josie, did you believe that the police had any ability to protect you or the kids if you disclosed that Derek had been harming the children?
No, because he always got out. He always got the charges dropped. He always blamed me, made me get the no contacts dropped, made me hound the DA.
Were you able to confide in Brian Moldenhauer about some of the abuse that was going on at home?
Yes, Brian was a very good friend of mine. He's one of those people that I've known for high school, and he's just never changed. He's been the same person since high school, and he's a farmer, and he's never been through trauma. He's just a really good person that I could talk to. And
Josie, you recall the 911 call where you said that Derek did the same thing to his 6-year-old as well?
yes,
Was that a moment of fear where you were you scared saying that even to the dispatcher?
I was, and I just spit it out, and I was scared.
And did anybody ever ask you what that meant?
No,
On the topic of protecting the kids from Derek, did you try getting a restraining order against him?
I did.
And do you recall in that restraining order, did you mention that Derek was becoming violent with the children?
Question is beyond the scope.
Judge, the state open this door.
It's overruled. Go ahead.
I know this is just.
Oh. This is a copy of a certified copy, but we have the certified copy here.
Let me see what you're talking.
Josie, I'm showing you what the Marcus 313. Does this appear to be a restraining order that you tried seeking against Derek?
Yes.
Did anybody help you with that?
Yes, a lady from Salvation Army.
Okay, so this was the social worker at the Salvation Army?
Yes,
I see the date on page 3 here is it signed June 25th of 2019. Is that accurate?
yes,
Would that have been the date that you signed it?
yes,
It looks like the notary is our current court reporter. Is that correct?
yes,
All right. So Josie, on the back, there was a section where you had to write what had happened with Derek. Do you recall that?
yes.
And
But for the purposes of this exhibit, I'm going to ask that be used for the limited purposes related to the children only.
Yep.
that's all I'm gonna use it for.
Thank you.
Yep.
And I'm just gonna highlight a section here. Did you write that Derek uses violent force towards the children at our home?
Yes,
What did you mean by that?
he was violent towards the children, and he would hurt them.
Offer 313 for the purposes used.
For the sole purposes he used,
For
to
that
be
purpose,
received.
yes.
Yeah, be received for that sole purpose.
Josie, what happened with that restraining order?
He didn't follow it, and
Judge, I'm gonna object. I don't think, can we have a sidebar on this?
Yes.
Let's talk about the house again. And we've already agreed that the house is pretty messy and pretty cluttered. Is that fair?
yes,
Do you think that you would have noticed if a particular piece of property like that purse was on or off the floor at the time?
no,
I want to talk about Derek's phone call to you after he was arrested on the 10th. Or excuse me, your phone call to Derek after you were arrested in May of 2023. Do you remember talking about that?
yes.
How were you feeling at that moment, Josie?
I was in shock. I didn't understand my charges. I had to keep asking the jailers what my charges were. I miss my kids. They were crying for me on the phone.
What did you mean, Josie, when you told Derek that you got what you wanted? I'm being blamed for it.
Before I got arrested, Derek kept telling me that
Objection, this calls for hearsay.
Yeah, sustain.
What did you mean by that comment, Josie?
Derek said he was going to blame me.
Objection, calls for hearsay. She's responding with his answers.
Effect on the listener.
So it's not being offered for the truth of the matter, only for the effect on the
Only for
listener.
why she would say that.
Okay, go ahead.
Okay, go ahead, Josie.
Derek said that when he was beating me at my mom's, that he was going to blame me for Alex's murder or death.
Why would you tell this man that you love him on the phone?
Because I was in a situation where I was alone. I wanted my kids, and I needed love.
I'm going to follow up a little bit on what you offered earlier with the state, but have you known Derek to have others clock him in or out of work if he was late or leaving early?
Yes.
Calls for hearsay.
The question was asked why she believed. This is what she believed. Go ahead.
He would come home and brag about it.
That's hearsay. I'd ask that be struck.
Given the situation, I'll allow her to answer that question.
So talking about that purse or the Coach bag, Josie, you said that you believed it was on the hanger shelf. Did you know that it was there for sure?
In my mind, I picture it was on there.
You know whether or not Derek accessed that bag while he was in the room with Alex?
I don't know. I didn't.
Along kind of the same lines, why did you ask to lift the no contact order with Derek after Alex died?
Because we had a mutual hurt in common, and that was Alex.
You gave some testimony that you wanted to feel something. You wanted to feel like Alex was still around. Is that
I
accurate?
did, and I just wanted to feel, even if it was hurt and pain, I just wanted to feel some type of closeness to Alex.
So Josie, you were asked why you couldn't take Alex to the doctor on Sunday after the birthday party. Do you remember that question?
Yes.
What was going on in your life where you couldn't take Alex to the doctor yourself on Sunday?
In the morning of Sunday, when we got back from the birthday, Derek had beaten me to the point where I could not move because he accused me of him getting beat up by the Hispanics.
By the Spanish-speaking men?
Yeah.
Was there any reason why Derek couldn't take Alex to the doctor on Sunday?
No.
Josie, in terms of the staircase, what efforts did Derek make to protect that staircase from children playing around it or falling on it?
He didn't.
He did nothing at all?
No.
Regarding the emails to and from Hinchin, the school district, Were there additional emails that we didn't discuss between you and the staff of Hinchin?
Yes.
Were you in fairly regular contact with the school?
Yes, they considered me a helicopter parent.
A helicopter parent, did I get that right?
Yes.
In terms of the text sequence that you were asked about where Derek swung by your mom's house to get something, would your mom occasionally have things for you, food or utensils or anything else?
Yeah, she'd pick up clothes for the kids. She'd pick up, if I couldn't afford Tylenol, ibuprofen, soda, water. I mean, whatever, you know, anything. She'd find something on sale. She'd pick it up for me.
Okay.
She was a mom.
And if that trip to your mother's happened the following day, do you know if Derek was still drunk and high, like you said on the 20th?
I don't know.
Why would you say in those text messages that Alex needs to be here at home healing and not out getting drunk and high with you?
That would have been the day before he went to my mom's.
And why would you say that to Derek in a text, that he needs to be home healing, not out getting drunk and high with you?
Because Derek.
This was asked and answered in direct originally.
Sustain.
Were you telling the truth when you made those statements on the text messages, Josie?
Asked and answered.
Sustain.
Did you have any reason to believe that those texts from the 19th and the 20th of January would one day be used in a homicide trial 3 years later?
Asked and answered.
Overruled on that.
No, I would not, and I wouldn't have wrote them if they weren't true.
Give me 1 second, Judge. All I have on redirect.
Recross.
I just want to touch briefly on the photograph that you were showing after sending the text message that said, I just showered, okay? The time frame where your phone has no activity is from roughly 7:47 to 8:29, correct?
I believe so.
Okay. The text message photo that you send to Rafael Suarez, the photo that we've seen in court, that's sent at approximately 9:20, isn't that correct?
If that's what it says.
Okay. And the photograph, you take a number of selfies according to your phone activity before you pick that one to send to your date for the next day, isn't that right?
That's what I usually do, yes.
Phones have filters on them, correct?
Yes, but
You're also sending a text message to someone you're going on a date with the very next day, correct?
yes.
Okay. You want to look your best. You want to show your best for that date. Isn't that right?
I mean, I guess, yeah,
People don't generally send a text message to someone they're about to date the next day with no makeup, nothing on.
I do.
You do.
Yes.
Okay. That's not what you did here, though, is it?
I already had makeup on.
After you showered.
I didn't shower.
I understand you say that today.
Any redirect?
Josie, did you regularly wear makeup to bed?
No.
And the time frame of 7:47 to 8:29, would that have been right after Derek was arrested?
I believe so, but I'm not good with time.
He was arrested around 7:30.
I think so.
Were the kids upset at all by the fact that Derek had been arrested?
Objections beyond the scope.
It's related to this timing issue. I'll allow that question to be asked.
Not this time, no.
Did you have some things to do with getting the kids to bed and getting the kids rounded up after Derek was arrested?
Yes.
Did you use a filter on your phone when you were taking those selfies, Josie?
I'm not good with the filters, and those are usually on Snapchat,
Okay.
other than like hints for the background.
And we don't see cartoon dog ears or anything on you, correct?
No, I don't know how to work those unless it's on Snapchat.
Were you wearing makeup in that photograph?
I was.
Nothing further.
Anything further on that?
Nothing on that.
Okay.
Yes. Thank you, Judge.
Please step down. Why don't we take a break for about 15 minutes and we'll go from there. 10 to 15 minutes.
You're all split out.
You know I'm here.
Yeah.
All the ones I need to move. Oh, yeah, that too. That goes without saying. 152. City records.
Arrested, that we need to wait tomorrow for some potential rebuttal witnesses. Probably my hope is that we will be able to do jury instructions tomorrow, maybe even closings tomorrow, and at least give them the opportunity to be able to deliberate all day on Friday. I know I'm always pushing it maybe a little bit too fast, but we'll see where we're at the end of tomorrow morning. Either way, closings would be at latest Friday morning. That's what I can see is doing like jury instructions, finishing them because jury instructions are going to take a while, just simply from what I understand. So let's bring the jury in right now, and we'll give them a break and go from there. Now everybody may be seated. Mr. Zacher, does the defense rest at this point in time?
Yes, Your Honor.
So, ladies and gentlemen, the defense has rested, which means we go to the next phase, which is the state has an opportunity for something called rebuttal. Because it's a little bit, timing was a little bit off, what we're going to do is start that tomorrow morning. So we're going to be done with today. My hope that, knock on wood, my hope is this means that we should be done this week. Of course, there's no, as deliberations, as you've heard me say this before, I cannot tell you how long that takes. That's really up to a jury. But at least as far as the finishing of the full trial going to the jury, my hope is you'll have it no later than Friday at the latest. Good news. The other thing is, say, if you can come back tomorrow morning, 8:30, we should start right up with whatever witnesses, if there are any witnesses, and then we'll go to the end of the trial. Thank you so much. Please don't talk about the case as usual. See you tomorrow. Oh, shoot. I just realized that. No, it's okay. Everybody may be seated. Just let you know, Christina is taking what was sent to by the state to the and is now we're incorporating it. Of course, we can discuss it. That's just to have so we can talk about the entire thing at that point in time. Sort of what I usually do is I make copies of the instructions, giving you both copies of it. I'll have her send you an electronic version of it too, and then we can start working through it. Probably not till about 3:30 is when I think we'll be ready. She's working on it as we speak. One other question. This is a really Mr. Colkine's not being called as a rebuttal witness, right?
We don't intend on calling Mr.
Okay.
Colkine. There's
There's a logistic issue which we just need to clarify. My also hope is that we'll be out of here in a decent time today and then tomorrow, of course, but regular time. Anything else we need to talk about while we're waiting for that to be done?
Judge, I would like to argue the objections on the proposed rebuttal witnesses.
Okay, why don't we do that right now? Go ahead.
So, Judge, as the court recalls, Dr. Iniguez was excluded on a couple of grounds, both relevance and as well as in the context of the Daubert hearing, as well as the discovery violation. What we're looking at here is whether or not this is bona fide rebuttal, as defined by State versus Cacciatolo and subsequent cases. Bona fide rebuttal is not any evidence that the state wanted to put in this case in chief. It's not evidence that's defined by context or providing additional information. It's in direct rebuttal or response to our case. We were very careful not to open that door to Dr. Iniguez testifying on rebuttal to these issues. Both Dr. Christensen and Dr. Quentin testified that this would be expected to be a painful injury. We didn't contest that testimony. They testified to that. I agree the court or the state can argue that, but there is no disagreement that Dr. Iniguez is coming in to rebut. Rather, the testimony that's coming in a rebuttal is testimony that the court excluded in the state's case in chief, and they're just trying to backdoor this as rebuttal evidence. It's not in response to anything that we've raised, and particularly if it's just being offered for context or information as to how a child might react in that situation. That's evidence that a reasonable prosecutor should include in their case in chief, in direct, and was excluded by the court as a result of the discovery issue. As to the lab evidence, this was evidence once more that a reasonable prosecutor should have tested and produced before trial. They had 3 years to send this to the state crime lab, and they didn't. We also intentionally avoided opening this door. Attorney Torbenson emailed me, I believe, last weekend, saying that they had this tested and the presence of sucrose was detected, and advised me before I cross-examined Sergeant Amundsen as to that. In the process of this, I asked Sergeant Amundsen a very specific question before trial. were any of these substances tested? And he said no. I did not ask subsequently. The state did not redirect with subsequently. We intentionally did not impeach Sergeant Amundsen with comments on the body camera where they're describing on the body camera, looks like it could be a pill fragment when collecting this evidence for that reason. I didn't want to open up that door. Additionally, I think this is problematic in that we requested a copy of the report or any other documents immediately after we were notified of this because what the state's describing is effectively exculpatory evidence, where this is also inconsistent with the state's theory of staging the scene to make it appear like an accidental overdose. We've received no reports at this point. Obviously, I don't have a multi-million-dollar crime laboratory on retainer to get this evidence retested in the meantime, but this is not within the scope of rebuttal to say that we didn't test this throughout the case. Now we're going to do it mid-trial and introduce scientific testimony, which has yet to be disclosed to us, contesting consistent with the state's theory of the case. It's evidence that should have been tested. It's evidence that should have been tested a long time ago. Yeah, it's also problematic in that, as the court knows, my wife works at UWL. I know a number of these people. I don't know who they're going to produce, but these are certainly people that I've met and have interacted with in the past. But just looking at this, I think, one, it's a violation of the state's obligation to continue to disclose exculpatory evidence as it came in. It's arguably exculpatory. Two, I don't think that this is bona fide rebuttal evidence as defined by Cacciatolo in direct response to something that we did here. The issue was, were they ever tested before trial? They were not. The state can't come in then and produce scientific evidence that we have absolutely no opportunity to rebut. We have no opportunity to assess the validity of this. If it's a student assisting with testing, if it's a test that's specific to sucrose or specific to or includes testing for controlled substances in addition to that, it's too little too late. I think that this is unfair surprise and that this evidence should be excluded in its entirety.
Let's talk about the lab testing first. Why don't we do that first? Go ahead.
All right, State versus Hatcher is the case that says that an issue that is raised during cross-examination by defense counsel can lead to rebuttal evidence on the part of the state. It's always been our theory that this is sugar. We said it from the start. We've talked about this being the cotton candy that was all over the floor, on the pajamas, and in the bed. That was the testimony essentially of Investigative Sergeant Rich Amundsen when he took the stand. The first I've heard of a pill fragment, and pill fragment was used throughout the questioning of multiple of the on-scene initial responding officers by defense counsel. They also used pill fragment when they were questioning Lieutenant Williams, when Lieutenant Williams was on the stand and not having the pill fragment tested. That raised a bona fide question. One of the things that State versus Hatcher talks about is that a jury trial is a truth-seeking function. The truth-seeking function here is having the testing completed and demonstrating that it is what we always purported it to be, and that is sugar. So the substance was tested. As soon as this issue was raised, we made arrangements, not with the Wisconsin State Crime Lab, because they test for drugs. This is not drug testing. This is testing to verify that it was in fact sugar, which is what we believed and not what the defense was suggesting it was during trial. The testing came back as sucrose at a higher than 98% rate. It's been compared to other sugars, including other sugars that are often used in pills to constitute Xanax pills. It's lactose that's actually used in those pills, and it doesn't come back consistent with lactose at all.
So the people who tested this, did they know that?
They knew that sucrose was the main ingredient in.
But they're not experts in pills.
They're not experts in pills, and I don't anticipate them testifying about contents of pills. But I'm providing that information to the court to know how careful we were being in having this testing conducted. The student that tested, it's actually not a student. It's a doctor. His name is Alex Paulson. He just transferred to the university from Michigan last year. So he's been with the University of La Crosse for 1 year.
Judge, could I respond on the legal issue?
Go ahead.
Hatcher, as I understand it, is an unpublished but persuasive opinion. The opinion that I would direct the court to was State versus Konkol, Konkol. That was a case that addressed bona fide rebuttal with fingerprint evidence, where in that case the state was surprised by the defense indicating that he only had one beer with a 0.12 BAC, and they were permitted to introduce fingerprint evidence on other beer bottles or beer cans, I believe, to rebut that defense. The issue there was legitimate surprise. This should not have been a surprise. We viewed these pills, they were collected, or we viewed the substance, it was collected. It's something that's been on the radar for a long time in this case. And additionally, professors' findings here in the testing on this substance, we're entitled to a Daubert hearing on that. If they're going to discuss the veracity of these tests or the range of substances that were tested for. And I mean, that would be my request, is that we have a Daubert hearing on this matter as well, if this introduces.
But you don't have the report, right?
I do have the report. I can have it sent right now. I think it was just the final report was provided to
But as we speak, he does not have the report. The state doesn't, the defense does not have the report, right?
We just got it.
All right. Two things. One, I don't think this is a surprise. I think this material was all over the place. It was there. It could have been tested by the state a long time ago. It's been around 3 years. Actually, there's been a lot of evidence here that there's cotton candy, et cetera. There was brought to the attention that this did not look like it was a pill, et cetera. It wasn't tested by anybody. Having this type of testing is not, well, first of all, it was not a surprise because it was always around. It was in the scene. It was collected by the police. If there was a statement by, it was an officer who said it was a pill fragment, I believe in the video.
Well, it was Deputy Jar talking to Sergeant Amundsen on the body camera, where they said something to the effect of, sure looks like it could be a pill fragment, could be candy, we don't know.
Right.
Yeah.
So at that point, that was evidence that comes from day one, moment one in the case. If the question was raised, and this is not a surprise to the state at all. I agree that there would be a whole process of having, you might have the report right now, but they would also have a right to test it too, if they wanted to test it. So I'm not going to allow that lab evidence to come in. That's going to be excluded. Now, why don't you argue the other the issues of the Dr. Nunez? I apologize if I'm mispronouncing your last name, but go ahead on the issue of the doctor.
Me or?
Yeah, I think they already made their argument that they believe this was, they made the argument earlier. Actually, and I do have a question because this goes back to the original discussion we had just before we took the break. You said her testimony would be really more of an elaboration of what a child would feel.
She can provide more details regarding the symptoms of the child and the time frame for those symptoms because she deals with live patients and not individuals who are dead and performing autopsies. So she brings that unique experience. And in the testimony of Ms. Dikeman specifically talked about not really seeing any symptoms or not really seeing any symptomology. And I think in particular in this case, the symptoms that Alex Xavier would have had and the timing of those symptoms is actually a big issue.
And especially if the theory that if the theory of the defense is that this just happened only moments before he was arrested or within an hour or two of being arrested. So she's rebutting essentially what's being asserted by Ms. Dikeman, is what you're saying?
By Ms. Dikeman, that these injuries were inflicted during the narrow time frame that Mr. Pedram was there. Yes.
Or the observations of the pain, in other words. It's really a rebuttal of the observations of the pain. Is that correct?
Yes.
Okay. All right. I'll give you an opportunity to respond to that.
Judge, it was something that was both raised with both pathologists who testified as to the pain that could be expected. We knew that to be testimony in rebuttal to Ms. Dikeman's preferred testimony. It was effectively done. This is something that the state noticed with Dr. Iniguez in the expert testimony that was excluded on direct. That does not make this bona fide rebuttal to say that we want more context or more information. The jury's already heard that testimony. And this again is surprise. We're going to bring in it's something that was well known to the state that this would be an issue in advance. It was something that was contained in the various expert notices. I don't believe that we opened that door at all. In fact, we didn't object to the questions about pain level that a child could experience under those circumstances. This is more of the same of what the court excluded. It's not scientifically reliable. Dr. Iniguez's experiences, however many or however few that she has, are not relevant to assessing how Alex Xavier would have reacted. But we've got two forensic pathologists that have already testified that yes, they would expect this to be a painful injury, and yes, they would expect the child to be exhibiting symptoms. It's not in response to anything that we have presented in the course of our case, and therefore it's not bona fide rebuttal.
So first of all, on the qualifications of Dr. Iniguez, she's a specialist in the area of unintentional injury of children, specifically, or intentional injury of children, specifically when there's multiple planes of injuries, the severity of the injuries. She testified to that. She has the background in that area. She also testified to her qualifications and the research that she did. I did say at the time that I could see that she meets those qualifications to allow her to testify. The real issue that it came down to, which excluded the testimony in chief, was the issue that the court felt that it was basically the report was not turned over until we actually had the Daubert hearing, which was too little too late. What the court will say is that I believe she can testify to a very limited purpose, which the state has outlined. Talk about these type of injuries would cause this type of pain in those she has worked with, and those what she knows from whatever research she knows. But it's only about that issue. She's not to talk about, it's her conclusion that this is a intentional infliction of injuries. What she can talk about is these type of injuries cause this type of pain, and when you would feel it, basically, because you would feel it soon after. I'm assuming the testimony will be soon after it's inflicted. Is that clear enough?
Pain and symptoms is the way I understand.
Pain and symptoms, yeah, pain and symptoms. So she's allowed to testify to only that limited purpose.
Judge, I'd still like to doubt Dr. Iniguez on her experience and rationale for her testimony in that matter.
We had a Daubert hearing. She seemed to have testified about her experience with injury. Are you talking about where the pain is?
Where the pain is, what experience she has with patients with this particular injury, how she can make that description, whether or not she can generalize that description to all children.
All right. What I'll do is we'll do a small, on that specific issue, we'll do a small hearing on that. I'd actually sort of like to hear what her testimony is so I can understand exactly how this will come in. But not only that, I think with her experience in this specific area, meaning the injury and its effects, without going back to it, I allow a little bit of idea about that issue beforehand. So we'll be very specific area. I'm still at this point inclined to allow her in, knowing what I do know what she knows, unless there's something that comes to our attention in this process. But what we'll do is that if you can have her at 8:30, is that possible?
Flying in from Cleveland, so I don't think she'll be here until late morning. We're working on maybe getting an earlier flight. I'm not sure if it's possible, but we're trying. We didn't anticipate the defense resting today.
Yeah, I forgot she was in Cleveland. For some reason, I thought, yeah.
We're trying to get her in earlier, Judge. All the wheels are working downstairs to see if that's a possibility.
Okay.
We'll come back for jury instructions. We can have nothing.
Yeah, why don't we find out when she can be here? But I'll allow there to be a Daubert hearing either way.
Judge, yeah, I'll just put on the record that I don't believe this is in any way, shape, or form bona fide rebuttal. We're being sandbagged with an expert that we are not able to provide a rebuttal to.
I would just note that this topic was actually addressed in the Daubert hearing. I did bring up because I think the defense was actually, they said that my notice didn't contain symptomology, but she talked about her history with working in a trauma section of a hospital for a number of years and working directly with patients, including patients with these injuries. We had a 2-day Daubert hearing, 2.5 days, I recall. And this topic was well-versed and well-covered during those hearings.
Yeah, I remember this topic being talked about. I'm not sure why this defense believes it wasn't talked about, but let's, but I'd still allow there, because this is a really particular area, I still allow there to be a voir dire. I do not expect to spend more than a few minutes on this issue. I'm not going to spend like 2 hours on this, 3 hours on this issue. So be efficient, in other words. All right, find out when she can come. I'm going to talk to, when do we have you guys come back? Let me just find out what Christina is saying about being ready.
Judge, may I ask a question related to closings?
Sure.
Are you imposing time limits on the parties?
Well, it depends a little bit when it happens, but yes, there's going to be some type of time limits, but it has to be reasonable. I mean, I'm not going to make it 30 minutes or something like that.
I wasn't expecting that. But...
Yeah. I mean, I think you have to give me, looking at the openings, quite honestly, the States was very short. It was 30 minutes or something like that. Maybe 45. I can go back and look.
I think it was 54 minutes and Attorney Zachary was an hour and 16. So they're relatively close.
They're relatively short. So yeah, you might be right about that. So yeah, I mean, what are you thinking it will take the state to present a closing?
I was just looking from guidance from the court on what the court was going to.
If I gave you both an hour?
It's going to be longer than an hour.
It's not going to be much longer than an hour. I'll do an hour and a half. You'll lose a jury eventually. I mean, we've already been doing this for 2.5 weeks. So, so make it an hour and a half. You both have, it'd be total hour and a half.
Broken up.
Yeah.
Got it.
You. All right. All right. This might take a little bit longer. Let's say another, come back in about 20 minutes. Or about 10 to.
Oh, Judge, we would move to release Rebecca Ehlers from our subpoena. And my understanding is that the state is also doing the same.
Yes, we agree with that. And there's a number of other individuals that have been out in the hall that are asking if they can be released. If they are not on the defense list and we're not calling them, can all those individuals be released as well?
So long as the state is not calling them.
Yep, everybody is released who's not being called.
Yeah, and Attorney Zach, did you want to make a record about the evidence in the bag?
Oh, yeah, so just so we're tracking.
Gosh, I tell you, so many words for nothing. I don't even know what they talk about no more. I done always zoned out. I don't know what they talk about at this time of night. Oh man, oh man. All right, guys. Yeah, I'm done with that. I think that's enough for me. All that rest of that stuff, we'll figure it out tomorrow morning. Okay, guys, cool. We will get started tomorrow with our Folio, because Folio starts before this one. And then we'll get into this one. It seems like they're gonna have a couple witnesses, a couple rebuttal witnesses or something tomorrow in both trials. Look like we'll be going in jury instructions with both trials. It looks like we'll be going into closing arguments for both trials. So y'all know how we do it. We just get it done the way we get it done. Maybe go on a lunch break, do half and half there, and go on a lunch break, come over here, you know, run this on 1.5, but we'll get it all done. I know it's been a doozy today, huh? All our days been pretty long. We've been getting off around this time every day trying to take care of both of these trials, but it's cool. It's cool. I wouldn't want to watch it with anybody else but you guys. So that's what makes this even better, because it's stuff that I would have wanted to watch anyways. Does it make sense? So we good. Okay. If you are on the replay crew, make sure you drop a note, send a comment, reply to somebody else's comment. I don't care what you do. Just let me know that you was there. I try to get in there and I try to comment to everybody. I don't know how it does it. Sometimes it alerts me when people comment, and sometimes it doesn't. So I try to look at the comments, but then sometimes I get lost in the comments and I get to reading them, and the comments be so funny. Oh my goodness, especially when we talk about like this Folio trial. Oh my gosh, the comments are hilarious. I don't know. I'm like, these people were something else. They thinking of things that I didn't even think of when I'm listening to them. So definitely a good look. If you don't have, I think I'm almost sure that Film dropped the Discord link for anybody that wants to hang out on Discord. Remember, if you have any videos of any funny verdicts or shocking reactions from anybody, send them on in, drop them off in Discord so we can play them. They have been a wonderful end to our Folio days. Okay, let me get this link. Yeah, this link on and our what's the name? It changes all the time. Oh, I see your other one that you sent over here. Just Shamrock. Yeah, I tried to do that event thing. I don't know how. I gotta figure out. Maybe I have to Google how we can use it to work. I don't want you to think that I forgot. I did go in there. Oh, Drunky sent one too. Oh, awesome. So we got some for tomorrow. Awesome. Yeah, keep those coming. That's been fun. Yeah, that is fun. That is a fun time for us. I like that at the end of our thing. And maybe we'll do some kind of little combination thing. But here is the Discord link if you're not already signed up for Discord. It's free. Nice, fun place to hang out. It's where the after party happens, right? I already have the link set up for tomorrow for the Folio trial. I'll do Josie's kind of I'll do Josie as we go through the day, trying to figure out where we at. Do me a favor. If any of y'all see any, because we'll probably be done with these trials, I would say no later than Monday. Check and see if you see any trials out here or anything that we need to cover next week. I'll be looking too, but sometimes I miss it with doing other stuff. If not, I know we'll probably we'll start Murdoch this weekend and get some hours in with him. I don't know. I want Josie to go on the run. I don't even want her to come into court tomorrow. I want them to have to put out an APB for my girl. I want her to be like, look, I had this funny feeling in my gut, and I don't want no parts of that. Peace. I want her not to. I want her to go. Wouldn't that be exciting if they just come into court like we cannot find our client? Oh my gosh. I'd be like, she didn't went on. She probably got an ankle monitor on, huh? Well, the way Sean took his ankle monitor off when we was watching the Fulio trial, I don't see her being far behind it. Yes, Leia too. All right, guys, I am going to put on our outro song, and we will be back in here tomorrow. Everybody have a great evening. Don't forget your videos. Thank you to the mods. Thank you to the chat. Thank you to all the new subs, all the new members. We are growing. Growing. All right, guys.
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mods on patrol, chat is showing out. This little YouTube corner's what community's about. Therapists you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Marilia from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case so far, we're forever taken to trial. Take it to trial. Pretty brown girl, she'll tell you what's true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Paula brings the energy, jokes flying fast. Helping Sweet Pea backstage, making every stream last. Then Zach's trolling, causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case so far, we're forever taken to trial. Take it to trial. Shamrock keeps us trending, replay queen. Holding down the algorithm like a machine. SD's razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white cloth way, managing volunteers like she runs the whole land. Cynthia brings inside what takes sharp and steady. Donna keeps it real, 911 and always ready. Tilly Bird's the fat queen, receipts on tap. Easy's new, but she blends right into the pack. Tennessee, hard live, try support her with pride. Melly shows up a family for cooking for his dog. A steady carrying presence through the courtroom fog. And Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Baca loves her grand, speaks truth when it's time. Micrograms for metaphors, straight up sublime. Barbara, biggest supporter, heart kind of vast. Looking for missing kids, hope that truly lasts. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvy, I Irish Amy, Capri Law, Hellcat, or try. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. Mods and shatters, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. Sweet Pea and the mods in the chat we adore. This isn't just a channel, it's a family. And we couldn't ask for more.